40.
Certainly, the whole in that way, my lord. Both sides came out that way. Letter may be sent for arbitration, can be settled.
Item number 40. What do you want?
No dispute in that manner to send it to arbitration. Can be settled.
Let it be called up.
Hello?
Let it be called up. Let the item be called up. You submit accordingly.
That's also item number 22. Letter is wrongly listed for bench. The division bench letter on it.
What are you challenging there?
Armed Force Tribunal's order.
It is submitted by Mr. Goswami, done at CGC, that the writ petition is a challenge made to the order passed by the Armed Forces Tribunal, and therefore required to be listed before the division bench. So it has been wrongly listed before this bench stopped registry to make necessary verification and place it before the appropriate bench.
Hello. I am mentioning for admission, my lord. Listing, my lord, 4 petitioners, my lord. Common judgment, my lord. Their area salaries are not paid. My lord. I am praying for listing on 17, my lord. 2 of them are going to retire in November. 17.
All right, 17.
It is a lordship. Lordship, I beg to mention, I remember 15 will be considered the other side. Lordship.
15.
Lordship. My senior is out of station on medical grounds, my lord. Any other.
Item 15 is submitted that this is that matter which is going on for last 1 year. You wait.
He's on medical grounds, Lordship.
You wait. We call up the matter. Yes.
I beg to mention last.
Let it come in July. Why you 23 matter? Why you making mention now to be listed in June? Let it come in July. When was it last listed?
Last August 5.
5th of August. Why are you making the mention now in June? Have it in July. List on 17 July.
Yes. Item number 31.
31.
31. Respondents have filed affidavit. I have to file reply.
31, counsel for the petitioner. 31 is by order.
Not by order.
31.
31.
It's shown to be by order. You have made a mention for listing.
A listing.
For what purpose?
Since then, they were not to file affidavit, but now they have filed. So
counsel for the petitioner submits that. When did they file affidavit?
But if state has filed yesterday or
respondent has filed the affidavit, counsel for the petitioner seeks liberty to file rejoinder. Prayer made is allowed. List after 4 weeks. Yeah. Pension matter, 19 July, 19th June. Yes. 19 June.
My lord, these in the registration relating to the pension to the irregular master rule workers, my lord. Notice of performance, my lord, thereafter not listed, my lord.
19 June. Oh.
Chair, I to mention item 34.
3 and 4.
34.
34.
So, Chair, we are awaiting instruction.
Who's for the petitioner?
We have
item 34 and the request made on behalf of APTCL stand deferred to be listed after 4 weeks.
Yeah, please, Your Lordship. I beg to mention for listing a matter which was last listed 20th April. Lordship. Kindly fix the matter for 10 June.
10 June.
Lordship.
Why 10 June? 17th.
Your Lordship, I beg to mention for listing of a writ petition concerning the Department of Proceedings of against the petitioner.
When was it listed last?
Last listed on 2nd of April, and it was directed to be listed after 3 weeks. However, it is not listed till date, Lordship.
19th June.
Please, Lordship. The constitution of other party, I think 38, my lord.
38.
It's time to file evidence.
Item 38 of the request of the counsel for respondent.
Oh, my lord.
Petitioner. Petitioner. Matter stands deferred to be listed after.
Please, your lordship, I recommend for listing.
Admission. When was it last listed?
2024.
24, let it come in July. 17
Similar-
July.
If similar matter is placed on 8,
Similar matter is placed on 8th, we'll see about that. Then you make a mention after 8. Not now. Yes.
I'm paying 60.
Not Monday, July. Let it be in July.
60 was directed to 3 weeks.
Huh.
Just last listed on 16th.
All right, 17th.
I beg to mention hearing matter.
Hearing matter. Hearing matter will come for orders. Let it be listed for orders in July 17th. July 17th. For orders.
I beg to mention for listing the writ petition matter for motion.
When was it filed?
Today morning.
Today morning.
My lord, I beg for listing tomorrow, my lord.
Tomorrow.
Yes, my lord.
Why?
Because there is some urgency.
What urgency?
IOP, so has been served, my lord, and IOPU has been appointed on 19/5/26.
So where is the urgency? Go and face the inquiry.
My lord, simultaneous proceedings have been drawn.
Go and appear. Not tomorrow, 5th. Friday.
Vehicles. This is regarding pensionary benefit. Any day.
Let it be in July.
Gotcha.
July 20.
Fresh case, my lord. More, my lord, because it's about transfer of an employee, my lord, with a disabled child. It is the second round of
Friday.
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 Bring of listing of a 2022 matter, your lordship, in the month of June.
July
The dismissal from service lordship,
20.
otherwise I'm super, with my date of retirement, otherwise for service, is in September, your lordship.
Let it be in July. 15 July. Give you immediately after vacation.
I beg to mention for listing matter on Friday, motion matter. So it was fixed on 9th last Friday, but it's listed. I pray it was not listed on Friday, so it was fixed on Friday.
Last Friday.
Yes.
Let it
I
come.
pray for this.
Let it come on Friday.
Yes, Lord.
Fifth.
It was already fixed but not listed.
Let it be on 5th.
Okay.
Third counsel for parties is to notice returnable for weeks. Steps from the respondent by speed post within 1. Stop to return. Mr. Ayer Bhuya, senior counsel assisted by Mr. I will say for the petition. Obliged. Yes, Mr. Chaudhary, will you give notice for today?
Will not notice in the register.
Mr. K. N. Chaudhary, the senior counsel assisted by Mr. That's Commissioner in some returnable for steps from respondent by speed post within 1 week from today. That will be listed after return. Yes.
Before the not payment of
Huh?
the minimum pay scale.
Minimum pay scale.
Yes, sir.
So that has been interfered with judgment by the
That
Supreme
matter
Court.
has been interfered, but now I am saying for as per the judge.
Huh?
Judge.
As
Can
per
you see the
Jagjeet
page
Singh,
number
but
3,
your case is based on Upendas.
Yeah, the pay is only.
Ah,
I am paying for here only for the minimum pay scale here.
so that is all right. Minimum pay scale in terms of Upendas, Upendas has been set aside.
Said is again.
So
But
how are you
more
relying
benefits
on
are
the
given in that judgment.
Huh?
More benefits are given by setting aside the opinions.
So whatever it may be.
Can you see
In
the page
case,
number
what do you
3?
say?
Notice that
So we'll have to issue notice now.
Can you see the page number 3, madam?
Page number
3.
3.
Yes, ma'am. It is my cost agreement. I have mentioned the state of Punjab versus the judges. It's reported in 2007.
Oh, maybe, but you're also relying on Upendas. That was interfered with. So issue notice Let them say whatever they want to say. They have any. But Mr. Eboro, learned counsel for the petitioner, and then so the.
Or my lord, I may be allowed to amend the prior part.
Huh?
I may be allowed to amend the prior part.
Then you withdraw and file a fresh.
Fresh one.
Heard counsel for the petitioner, 6 liberty to withdraw the writ petition and file it afresh. Rearmate is allowed, writ petition dismissed on withdrawal with liberty. Yes.
Just correction of date of birth. Actual date of birth.
Notice for today. Notice that is heard. Mr. Reyes Islam, learned counsel for the petitioner, Mr. A.K. Goswami, learned.
Lordship, in this case, Lordship, the Lordship may dispose of this matter. Lordship, the petitioner submitted to representation. We are on the process to dispose of that representation, Lordship. With a direction, Lordship, their grievances is that regarding the correction of his date of birth, which is entrusted in his service record, Lordship. Therefore, we will rectify if it is according to the yes.
It is rectified.
Which
Case may be pending.
is submitted. to
He submitted representation.
Yes, Lordship.
Now, in
Now-
terms of your instructions.
Yes, it is
It-
on process, Lordship.
It is in process.
Within 1 month, Lordship, we will dispose of it. With that direction,
So
the
that
court may dispose.
That disposal, will you permit him to, will you permit his prayer or you refuse his prayer? Which one? Are you going to redress his prayers for correction? Then we are closing it.
Lordship, what is his prayer, Lordship? Prayer is that to, his grievances is that to, that not consideration of the representation, Lordship.
No. His prayer is correcting the date of birth. Direction to the respondents to correct the date of birth. Now, if you say the representation is pending, we are taking steps to correct, then we can close it. But
Yeah, we will correct if the proper document is able to furnish the proper
therefore, we are
document.
issuing notice, you get your instruction there. On the next date, if required, we'll close it.
I have my instruction, Lordship.
Saying what?
Saying, Lordship, the representation received, Lordship, accordingly, it is under process, Lordship, and under for consideration, Lordship. We will dispose of it shortly, Lordship.
But dispose of allowing his prayer or rejecting his prayer.
That will be depend on the
Therefore, he's filed the petition.
Lordship.
Unless you say that we are disposing it of allowing his prayer, he'll again have to come back.
Lordship, before issuing the notice, Lordship, the court may give us 1 week time
All right.
for disposal, Lordship.
You obtain instructions here.
Yes, Lordship.
No, disposal is not the issue here.
Correction is the issue, Lordship.
Correction
That is the issue.
Now,
Yes,
if you are disposing it of the matter,
Lordship.
the face of the writ petition, you might as well give the instructions to say whether his prayer is permissible or not permissible.
That's
Instead of disposing the representation, rejecting his prayer, again he's coming here, again you get your instruction. It's a long circuitous way. So get your instruction.
on that line. 10 days time may be required.
No, we issue notice. You get your instruction. You file your response at counsel for party. Always Mr. J.K. Goswami, additional senior government advocate, appears on behalf of respondent number 1, Mr. P. Sharma, 1, 4, and 5. P. Sharma for respondent number 3. For finance, anyone?
Finance, Lordship, Nayok is
That this
is
matter
P9,
be listed
P9.
immediately after the returnable date. Since the respondents are represented, notices are waived, extra copy will be furnished within a period of 1 week. Okay. Extra copy will be furnished to the standing council appearing for the finance department.
Lordship.
No, after returnable, to make a mention. What? Yes.
You have to obtain instruction whether he is entitled or not.
Will you be able to get instructions without notice?
What do you mean?
Heard counsel for party issue notice. Action mark. One week. It's after the schedule. Oh. Heard counsel for party. And Sharma for the Ghana CBC. What is your prayer?
My, there is the regulation of maybe
Regularizing. You're retired.
no regular on August. Retail.
You're retiring on
1 August 2026.
1 August 26. Why have you come so late?
I made verbal representations to the responsible authorities, but they no return.
Heard counsel for the party. Yes. Yes, for respondent number 1.
Yes, sir.
Mr. R. Dhor for respondent number 2. Mr. Nayak for respondent number 3. R. Dhor for respondent 2, 4, 5, 6, 7. Where is Mr. Dhor?
Or is post number 21.
Any other PWD council?
Or is here lordship, but
All right, inform me.
yes, sir.
We are issuing notice to the furnished to the period of. Take, serve extra copies on the council.
Proceed, my lord. It pertains to regulation, my lord. Annexure 1, my lord, engagement letter, 34 years, my lord, continuous service. Still I am getting salaries, my lord. And
Still you are getting?
salary, still I am getting salary, my lord. Kindly salary certificate at page 22, my lord.
What do you want?
So regulation, my lord. and other-
Regularization.
Yes, and other consequent benefits, my lord. Paragraph 6, my lord, in my support case, my lord, I have cited some case laws, my lord. Support my case, my lord.
You have to rely on the case law. Mere citing will not do. Where are the case law? Para 6.
Para 6, my lord.
Which paragraph? Which case law? Dharam Singh.
Dharam Singh is there, my lord. The another is, my lord,
Jago.
Mahanadi Coalfields. There are the cases, my lord, for my lord, any time, hearing, my lord, I will follow.
Yes. This is for which department? PHE.
PH, Public Health Engineering.
But my lord, he is serving under autonomous council.
You have not served copies on the standing council.
We have served, my lord.
Autonomous. Karbi Anglong.
We have served, my lord.
Mr. B.K. Sharma, learned counsel to the Mr. I. Bothakur, Public Health Engineering, Comprise of the young
One,
One and four.
1 and 4, my lord.
Let's comprise here for a smaller number. And five, Mr. Nayak for a smaller number. Three. It's after returnable.
Other candidate who are appointed earlier pursuant to same selection process. There is a appointment number. We have to
Appointed. There a direction to appoint you
Yes.
on a date when the others were appointed. Then your
Yes.
appointment will be from the date the court has directed you to be appointed, unless there is a direction that you should be appointed with effect from the date juniors or colleagues were appointed.
pursuant to same selection process.
Maybe, but you are appointed pursuant to orders of the court.
Yes.
So where is the direction of the court that your date of appointment should be with effect from the date when the others were appointed? Where is the order of the court?
49.
49.
Case 59.
Huh?
Start from case
Where
49.
is the operative portion?
Case 59.
59. So this order will be effective from the date when it is passed, that is 7/6/22. When were the others appointed?
Yes. Others 2021.
21. There is no direction that you should be appointed with effect from that.
They are not getting monetary benefit.
This was an issue you should have raised before the court, that while you are allow us from the earlier date. Automatically, it will not come. Direction is that the entire exercise should be completed within a period of 6 weeks.
Yes.
That was completed with effect from the date the order was passed. The order did not say that your appointment should have effect from and should be antedated. It's also what effect? Ultimately, there can't be an interpretation of the court's order. If you want, you can file a review against this order. But how can there be another order interpreting this order? Court has considered everything, allowed your petition, directed you to be appointed. Now, from which date the appointment order will have
That
effect?
is not there.
Not specified. How can it be specified by another court in a subsequent proceeding? Yes, you think about it. We'll have it on Friday. Next week. Friday. It's on Friday and the request made by the counsel to the petitioner, Ms.
M. Burman.
M. Borman appears on behalf of Mr. Ms. Iga and others. Friday.
Transferring him from Gauhati to West Bengal at the fake and end of his career loss. Whereas the honorable court has been always saying that discouraging the transfer of the lordship employees at the fake on the end of his career. They have not considered that.
When is he retiring?
He is retiring after 57 years and above. And at 60 years, after 3 years, he will be retiring.
Then what is the fag-in?
Lordship,
Where is it fag-in?
again, Lordship, it was only 3 years in the even if in armed forces also Lordship, this last leg posting provision is there. And he has served the Lordship.
This is not armed forces, this is LIC.
Lordship, even in armed forces, Lordship, so, that provision is there. In LIC, Lordship,
Is that provision available?
yes, there is 58 years. That is, may come to face the provision, the transfer posting policy. That is page 56, starts from page 56. Above all, Lordship, there is a medical issue in the family also. I have narrated everything and come to that. Page 56 is the policy. And regarding the page and the last page of this thing, Lordship, that is clause 11, page 59. It says about age of 58 years. 56 starts the policy.
How old is he?
Now he has crossed 57 years and 1 month. So, Lordship, and moreover, Lordship, his mother and wife both are seriously, Lordship, they are ill, Lordship, and under treatment. So, considering this, Lordship, the humble prayer is that, Lordship, at least his authorities should consider his case, Lordship. He has never paid earlier. And he has been posted from Gauhati to, Lordship, West Bengal. At least, and some Indian protection is given, and he was directed to relief from 1st June, Lordship. But till now, he has not been released.
Where is the impugned order?
Impugned order is at page 21. Lordship. It's a regular transfer posting order, promotion posting order. Lordship. It's not an
He's transferred on promotion.
promotion.
Then you'd want to forego your promotion.
It's the we want to forgo his promotion. But
Ah.
because of that, Lordship, the tuition at his home.
Where is the transfer order?
Yes, that page starts from page 21. It is not that under any administrative exigencies he has been, Lordship, transferred or posted.
No, but you are transferred on promotion.
On promotion, Lordship.
You don't want a promotion,
He wants, Lordship.
but he wants it in Gauhati.
Not only in Gauhati, and in Bongaigaon also, Lordship, I have pointed in my prayer also. Because of the family condition and he has to Lordship, settle his family also after his retirement. Everything.
Where is his name here?
His name is next at page number 24, page number 59. And moreover, Lordship, many younger persons, too younger, I have stated in paragraph also, younger than the petitioner, they have been retained in the original place of posting. In spite of that arbitrarily, without considering his Lordship, he has been transferred. Page 24, page number 59. Have been considering his inspector and the
Mr. A.R. Govinda, learned counsel to the party, is petitioner. The writ petitioner is an employee of LICI. And he's agreed by the impugned order of transfer dated 7/5/2026, whereby petitioner was transferred on promotion to Bordhaman, state of West Bengal. So petitioner is presently working as
assistant administrative officer
assistant administrative officer
at Gauhati.
at Gauhati. And he's transferred to Bordhaman on promotion as administrative officer. Stop. It is the submission of the council to the petitioner that as per the transfer policy, persons who are 58 years old are not required to be transferred out from a station, even on promotion, unless the place where the officer is posted does not have a vacancy in the elevated cadre. So it is submission that he's already crossed 57 years. And therefore, at this stage, a few months short, he would have been 58 and been given the benefit of clause 11 of the same transfer and posting policy, mobility policy. Stop. That apart, the petitioner, father and spouse,
Mother and wife.
mother and
Wife.
mother and spouse are suffering from severe ailments and requires constant medical care. At this stage, if the petitioner is transferred out, is the caregiver, they will suffer grave prejudice, as there will be none to look after his ailing mother, as also his wife. So, he submitted that along with the petitioner, several other persons were considered for promotion. Most of them were retained in Gauhati, in Assam, in Gauhati, including persons who were junior. But the petitioner has been transferred out for reasons best known to the authority. In representation filed before the authorities have also not been considered. So, in these circumstances, the petitioner is before this court. Considering the submissions made, let notice issue returnable 4 weeks. Petitioner will take steps on the respondents by speed post within 1 week from today. Trustee is also permitted to be looked through the registry of this court. And if service by way of trustee is undertaken, then affidavit of compliance can also be filed thereafter. So, therefore, stay affected by staying in having heard the number specifies that officers they get 50 years and above will not be transferred from a station, even on promotion, unless the place where the officer is posted does not have a vacancy. Petitioner is 77 years old, almost strictly not covered by clause 11. Nevertheless, claim of the petitioner that several other persons similarly situated having been detained in Gauhati and petitioner has been transferred to Bordhaman in spite of available vacancies in station. Court would like to examine the matter. Therefore, the next return will take state. This matter again on see, there is a vacation, so we'll make it returnable by 3 weeks. Let it be listed on 19th June. Take steps by Dusty. Steps within 3 working days.
Dusty, you can, some other places.
We are giving that option.
Option. Okay.
Short notice letter, weeks notice, while I respond to the that is.
Instead of that, why not get instructions if we issue notice? 2 weeks will say about 19.
Meantime, I will find if any of the one instruction I have received.
Why, we have affidavit now.
But parties, petition, filed with the petition, are praying for relaxation of age. Participating in this selection process.
Then the court assist.
of
One time major lot.
Stove, land record assistant. Pursuant to advertisement dated 14/3/2026 and issued by the respondent. Number one, stove petitioner submits that he is overaged by 3 years and has applied for relaxation. Let Mr. Andy, Learned Standing Counsel Revenue, obtain required instructions in the matter. Matter be listed again on 17,
19.
19. We are not issuing notice at this stage.
Lots.
So notices are not issued, extra copy furnished within 3 working days. Mr. Hendrik will obtain the required instructions on the next 8 days. 19.
Obviously. No, my lord, it will take time, Lord, because my lord, that, no, my lord, the amendment rule has been, my lord, brought. It was, my lord, stepped down by the division bench. So the process will be checked.
19.
This 85 and 86 years.
Huh? Risk and hard civil law. Third counsel for party will issue notice. Page number 79. Order of recovery shall remain stable. Mr. B. Chakraborty, done for the response.
Chief, the matter may kindly pass the report of timing.
Let it be in some other unit. There are so many matters.
Time being,
Senior is on leg.
Tomorrow or day after tomorrow.
can it not be after a while? 12 o'clock or whatever time suits you. After, for a while. Yes.
Wait, please. But the petitioner was a person to the selection process. Initiated sometimes in 22.
Yes.
He was appointed as a Gram Pradhan. Earlier, we used to call it Gambura Mila. Then we learned the respondent number
Hmm.
4.
You're, 49 days ago. 49. 48.
48. Told us.
Yeah. 48.
Lord, he was appointed as a Gram Pradhan in March 2023. You know? Now his selection was challenged by one of the unsuccessful candidate before the appellate tribunal. The appellate tribunal has interfered with the selection solely on the ground that the preference clause was not
In favor of the respondent.
Yes. Now, my lord, the lordship knows there are quite a few judgments. One of the judgment authored by Honorable Justice, Chief Justice, my lord, Rajeshwar Das, who said in these judgments, he said, my lord, the question of preference will come only when other things are equal. Now here, mark-wise, I have got marks above, and he got less. So therefore, the question doesn't arise. Kindly see, my lord, the order of the appellate tribunal. The impugn order starts from page 51. So lordship will kindly come to page 55.
Yes.
Order part at page 56.
In the light of the foregoing analysis and upon consideration of all facts, circumstances, documents, evidence placed on record, the following findings are arrived at. Score sheet for the interview held on 21/21/23 for the post of Now Pradhan Village so and so disclosed that 0 mark were awarded to all the 6 candidates under the criteria claim of former Gaon Panchayat without any recorded justification. The appellant Sri Gokul Kolita is the brother of Liladhar Kolita, who serves as a Gaon Pradhan of village Merua until his superannuation on 31/7/22. The very vacancy which triggered the present advertisement. Appellant's eligibility under condition number 5 of the advertisement is supported by certificate of Gaon Mojadar, Dipilia Moza, and the certificate of the in charge Gaon Pradhan so and so. The non-award of any mark to the appellant in this category is without justification. Now, Milord will kindly come to the clause. Where is the scope of awarding mark? Page number 22, Milord. Milord, I'll read that the vernacular portion at page 24.
24.
Yes, that vernacular portion, Milord. Serial number 5 on the right hand side. গাঁও প্ৰধানৰ পৰিয়ালৰ সদস্যক অগ্ৰাধিকাৰ দিয়াৰ লগতে বিবেচনাৰ সময়ত সংশ্লিষ্ট মৌজাদাৰৰ মতামত লোৱা হ'ব. So that means preference will be given and the views of the Mojadar will be taken. What is this question of awarding marks, Milord? And admittedly, if your lordship kindly comes to the marks, the sheet of marks, Milord, page 28.
Yes.
Page, I got 21.32, he got 19.66. So, Milord, preference will come only when other things are equal. Otherwise, that's a settled proposition. Then issuing of an advertisement makes no sense. And government appointment me, Milord. It is the appellate authority who has interfered. Milord, I am still holding the charge, Milord. My humble submission is, Milord, pending further examination of the matter, Milord, the appellate order should be stayed.
Yes. So the respondent.
Yes, Lordship.
Private respondent notices will go, Milord.
Lordship, I am hearing on behalf of the
What do you say?
Lordship, there is a statutory provision, Lordship, it is 162.
Executive instruction
No, no,
162A.
D is there, Lordship, review against the appellated order of the appellated authority before the additional chief secretary, revenue and disaster. 162D. And till then, Lordship, court may protect the petition. Now he is working
If we
as
are
a
to
government.
protect,
No.
if we are to give a protection, relegating them to file a review, then it will be forums.
Now he is in charge of that lot. Lordship.
And I have not,
Yes.
my charge has not been taken over, that's why I'm continuing. But
Yes, sir.
any day it will be taken over, Milord.
But review provision is there.
Yes, it is there, but where
These
there
all
are questions of
26
law
is
being raised, alternative remedy may not be a bar.
far always. And there is violation of fundamental rights.
It appears to be in conflict with the settled position of law.
Yes, Lordship. This may go, Lordship. But the appellated authority, they may go for review. This is the statutory provision.
So that is right, that is an
Yes.
alternative remedy,
Yes.
but is subject to restraint that it appears to be out and out violation of the settled law of this court.
There is a mark, not the 50 marks to the another interview, one of them, Iba and others. The marks has been given in as per the one of that from.
What I am finding strange is the government has appointed They are supposed to defend the government's order. I don't know whether nowadays what culture is good. Government appointed me. They're supposed to defend government order. Anything comes, there has to be opposed. I don't understand.
Will issue notice here?
Yes,
notice may go, Lordship.
Transfer of case 28.
28. Yes.
So, my lord, that the 50 marks will come, my lord, this another digit head.
Under?
My lord, that education qualification is 10 marks.
Ah.
Is the 20.
Ah.
Personality test got to 10 marks. Claim of the family former Gau Pradhan is 10 marks. Modara view is 5 marks. Previous experience is 5 marks. General awareness marks is 10 marks. Total is 50 marks. So, out of the 50 marks, the he is the family one of the person for the family member was the ex Gau Pradhan. But that marks has not been given.
Right.
Because of that, my lord, this prisoner, my lord, the appointment order was set aside by the appellant.
Right. How much
If
mark?
it is given,
How much marks are required to be there? I mean,
maximum
marks.
is 10 marks.
10 marks.
Maximum is 10 marks. Out of 10, my lord, he may get, my lord, 5 marks also, 6 marks also. Already depend upon our selection committee. Selection committee. That marks is not given to the my lord, that person. Only because of that, my lord, that the marks, the difference is given.
We'll examine that
Not-
matter. Right. Because this is exactly what is held by the division bench of this court.
Yes, Rajeshwar Das.
This or that is given, my lord, they are sitting, my lord, that the hereditary post, it is, my lord, that because, my lord, that his father was the, my lord, Gau Pradhan, my lord, his son will be entitled to
Same-
for the
same
but
woman
it has
interpret.
not been given. Only, my lord, the marks has been given.
But the
But
court
if it is, my lord,
has
marks is given,
said,
then, my lord, difference will become.
that's right, so marks will have to be equal first.
So,
Have to be
no, my lord,
equal.
that the extra marks has been given, my lord, the ex Gau Pradhan. My lord, that was, my lord, given in the, my lord, that-
You are saying that this claim for family of Gau Pradhan,
yeah, ex Gau.
ex Gau Pradhan is a head under which marks will have to be given. Not a question of preference.
Not a
So that is what the appellate authority says. Appellate authority says it is,
not given, lord. My lord, that
no, but it says it is a preferential
no.
mark not given. Who is in charge of the Gau Pradhan? Who's holding charge?
I am holding charge. The
Now, my lord,
statement.
the petitioner is holding.
So let him hold charge till the returnable date. We'll
Yes.
examine it.
Lord, ultimately, kindly to the page 52, lord.
52. Ah. Which paragraph?
But the second paragraph, lord, in person to the advertisements. From the top, it is said, my lord, 10 men. Person to the advertisement, the appellant and the 5 other candidates included a response number 4 applied for the post. The official respondent issue calling letter and the held an oral interview on so and so that before the district selection board. The
No,
district,
but it is not a case of the private respondent alone having a preference. Even the petitioner is required
no,
to
no,
be.
if my lord, the petitioner is also my lord, the ex son of the ex Gau Pradhan, all the my lord, the family member of the Gau Pradhan, he will also get the same mark.
That is what is written here. Paragraph 52. First para.
Lord, belonging to the family unbroken to the linkage, but this is the appellant, Lord. Appeal filed by the respondent of court.
Right. Then you read further.
Lord, the gap. Gaon Pradhan of the village so and so, grandfather Borsako Kolita
Okay, it is
served
only in respect of the appellant.
only respond of the one of the appellant.
The respondent four does not belong to that
No,
family.
no, no. no. The petitioner does not belong to the one of the ex-Gaon Pradhan. Written only because of one of the appellant.
Milord, I am
who is the
relying
family
on
member of the
division bench judgment of this honorable court. If your lordship will kindly permit me, I can place it. And it's two division bench judgment. Milord. Para 12 of the judgment. Milord.
Which
Raja Ali.
read
And we have this para 12, Milord.
Read a bit.
Read a bit.
Ah.
Sir,
Yes.
para 12, Milord.
Read a bill. There's no para 12. Single bench or para or read a bill.
Single bench para 12, Milord, which was upheld.
Question of preference.
Yes. And this has been upheld in writ appeal. Then if your lordship will kindly have Rajeshwar Das, Milord,
Yes.
please come to paragraph 18. So
Yes.
far as suitability aspect is concerned, the fifth respondent has never been evaluated to be number one amongst the competing candidates. The circle officer in his report observed that fifth respondent lacks proper knowledge for the post of Gambura, but at the same time awarded more number of marks to the fifth respondent as against the appellant. The contradiction has been noticed by the second appellate authority. It is under those circumstances second appellate authority concluded. No, I'm sorry, this is not the paragraph. Para of 14, Milord. Para 4, I'm sorry. Now we shall proceed to consider the question as to in what manner claim of the family of Gambura are required to be considered by the authority. We have already referred to the instruction which mandated in the matter of appointment of Gambura, the claim of family of Gambura, the views of the Mozadar, and suitability of the person for the post are required to be taken into consideration by the appointing authority. There cannot be any doubt that whatsoever that the office of the Gambura is not a hereditary one, no family member of Gambura as a matter of right can claim for being appointed as a Gambura. But at the same time, the executive instruction which remain unchallenged provide the mandated claim of the family is one of the factors to be taken into consideration along with the other factors. If your lordship should kindly come to the last three lines. In our considered opinion, all things being equal, the claim of the family member of Gambura may have to be preferred, but not at the cost of suitability of the person for the post.
Yes.
Law is well settled as far as this honorable High Court is concerned. That this preference aspect will come when other things are equal.
Ex-Gaon Pradhan, my lord, member of that Gaon Pradhan, my lord. Only the marks, my lord. That mark is not given to the my lord that the private escort number 4. It is not given the one of the difference is given, my lord.
But then you go contrary to the finding of the division controversy,
Rajeshwar Das, that matter also goes to the apex court also. And the controversy of my lord. After that, my lord, this rule has been earlier that is
there from earlier. Same was interpreted.
you are saying that Rajeshwar Das has been interfered by the apex court.
It was my lord, file my lord that the controversy Rajeshwar Das versus controversy was there. It was my lord the controversy preferred and appeal my lord that file SLB before the Supreme Court.
What happened there?
My lord that Supreme Court was directed to my lord frame my lord that rule regarding my lord appointment of the Gaon Pradhan lord. After that, my lord, we have given my lord. We have my lord that
Where is the judgment?
that is not my lord. Some other I will go.
No, well, I have already
Take it
placed
up
that
at-
vernacular version at
Give us
page.
the particulars, take it up at 2 p.m. Day itself. Give us the citation, control for us.
At page 24, I have already placed that, my lord. গাঁও প্ৰধানৰ পৰিয়ালৰ সদস্যক অগ্ৰাধিকাৰ দিয়াৰ লগতে বিবেচনাৰ সময়ত সংশ্লিষ্ট মৌজাদাৰৰ মতামত লোৱা হ'ব. That means preference will be given and view of the mozadar will be taken. It nowhere says that you have to give some mark or something.
So, but he says it is in terms of the order judgment of the Supreme Court. Let us see what.
Yes, yes. I don't think that this judgment has been overturned, Miller.
You can give us the citation, the court must.
The Supreme Court is judgment also.
We'll take it up at 2 p.m. or on Friday.
Till then status quo. On Friday, till then status quo.
But
So that
without-
I am not disturbed.
Without,
No, Miller. They
without
might.
really understanding position.
No, what I am saying is, Miller, prima facie, Miller, my learned friend, what my learned friend say is, Appellate Court has said that you frame a regulation.
Whatever it may be, but
Yes.
without looking into the judgment, may not be proper to.
Let it be today at 2 o'clock.
All right, at 2 p.m. All of the matter.
Made to your lordship. My lord, the petitioner was appointed as a professor of community and family medicine in AIMS Gauhati on 22/7/2023. An initial appointment was for a period of 2 years on probation. Now, my lord, while continuing, my lord, actually what had happened, my lord, there was another case where, my lord, that particular lady faculty member was subject to, my lord, sexual harassment by a particular faculty member of the institute. Now, the petitioner was one of the member of that the internal complaint, and the internal complaint committee gave a finding that that particular faculty member is guilty of, my lord, sexual harassment. Against that, my lord, and Ministry of Health and Family Welfare containing serious allegation against significant various officers of AIMS. Can this be my fault, my lord? Because I have genuine grievances, I represented to the ministry and the PMO. That's why, my lord, this show cause notice has been issued. Because I am on probation, my lord, tomorrow I will be, my lord, dismissed, or they will release me. And secondly, my lord, the respondent, the Mr. Ashok Puranik, is the executive director. He is nobody, my lord. He cannot. Governing body is the, my lord, disciplinary authority. And my lord, kindly see, my lord, the issuing warning letters, these, that. And my lord, in my representation, I have clearly brought out everything, my lord. They have extended my probation by 6 months. Lord, my only, my lord, initially I was the head. I was removed from the headship. Then I requested the authority, why you have removed me? They say it is based on some inquiry report. Then I wrote, then please provide me the inquiry report. I'm a head of the department. I'm sought to be
No,
removed.
but you are on probation.
I'm a probation. Probation.
You're still
Because
under
AIMS
probation.
was, yes, I'm still serving.
No, you are still under probation.
Yes, I'm still on probation. That's why my problem, my lord. Because tomorrow they might say that my performance is not suitable. I can
Where
be
is
released.
where is your appointment order?
Yes, page 80, my lord.
80.
80. Purobi Fukon, with reference to your applications and subsequent personnel interview based on the recommendation of the Standing Selection Committee and approval of the HR subcommittee, the competent authority of AIMS is pleased to offer you appointment to the post of professor in level so-and-so of pay matrix as per 7 CPC, minimum so-and-so, allowance as admissible on regular basis, Department of Community and Family Medicine as All India Institute of so-and-so on the following ground. That you will be on probation for a period of 2 years from the date of appointment. Your period may be extended or circulated at the discretion of the competent authority.
2 years should have expired.
Expired. Now they have extended my probation. Because in the meantime, my lord, I was removed from the headship on the ground that there are again complaint against me. There was some inquiry. everything started when I said, which are the inquiry report against me? That representation, if your lordship will kindly come to page number, my lord, page 88. It all started with this, my lord. On 21/11/25, I request a copy of the report submitted by the fact-finding committee, based on which competent authority decided to remove me from guideship. As this decision directly concerns my professional role, responsibilities, and reputation, I am entitled to know the factual basis, findings, and reasoning that inform this administrative action. Access in this report is essential for the following reason. Till that, my lord, I have not been given anything. When I did not get any response, my lord, then I represented to the Ministry of Family and Health Welfare and my lord PM. Now, because I have represented, they say these are all false. Therefore, my lord, they have issued the show cause notice. And the show cause notice, kindly see, my lord, I have been given only 7 days time to reply. It was issued on 27/5/26. So today the 7 days is expiring. So lordship should kindly come to para 8 at page 123. You are requested to ensure that your reply is specific, fact-based, and supported by verifiable evidence within 1 week from the date of receipt of this communication. Your written explanation reply, complete in all respects, supported by documentary evidence, should reach the undersigned within 7 days from the date of receipt of this notice, failing which it shall be presumed that you have nothing further to state in the matter and appropriate action will be taken, expert in accordance with the applicable rules. So my humble submission is, my lord, this show cause notice, that is there, okay, but no action should be taken based on this show cause notice until as may be decided by your lordships, my lord, in your lordship's further orders. Otherwise, my entire service career will be at stake.
But why have you not submitted your reply?
My lord, how can I?
Why?
Because he is not the authority. He cannot call for it, my lord. My disciplinary authority is the, my lord, governing body. And I am alleging bias against him, my lord. Can, my lord, a complaint filed to the PMO by itself be construed as an act of indiscipline? My lord, he is very vindictive person, my lord. In fact, the observation which I placed at 131, it was in the context of that lady faculty member, my lord, who was subject to sexual harassment. What he did, my lord, in that case, when the report of the internal complaint committee came, instead of acting upon it, a proceeding was initiated against the faculty member, and the hearing official was respondent number 6 in that proceeding, my lord. He was given a let-off. And that is not the procedure, my lord. Once there is a finding of the internal complaint committee, then either they should treat it as an inquiry report and proceed further, or the department may issue a departmental proceeding by issuing a show cause notice.
Proceedings can be initiated by anybody, not necessarily the disciplinary authority.
No, my lord,
It may be authorized.
Supreme Court, my lord, there is a judgment of the Supreme Court.
It may be authorized.
No, my lord. Yeah, it was said, my lord. Going by the language of Article 311 per se, it may be. But once rules are framed, then that cannot. That's the Supreme Court's view. It does not mean that anybody other than disciplinary authority
No,
cannot.
no, what if they're authorized?
My lord?
They have been authorized by the governing body.
No, no. They have not, my lord. Not all that I am saying is, my lord, I am saying the decision-making process. If based on the counter affidavit, lordship finds that the procedure prescribed was followed, otherwise. But in the meantime, my lord, if something amiss is done, then, my lord, I will be highly prejudiced. All that I am saying is, my lord, they will not take any step pursuant to the show cause notice, or status quo of my service should be maintained as on.
So that as on date would be giving a blanket order.
No,
Because
at least, my
you are
lord,
essentially questioning
yes.
the show cause notice.
No, well, I am questioning two things. I am saying there is no occasion for this so-called notice, number one. And secondly, you are not the competent person.
Right.
Hello, Supreme Court has said that by reading of 311, per se does not appear that the appointing authority must initiate a GP.
Right.
But if there is a set of rules, then the rules has to be followed.
Where is the judgment?
Judgment has to be- There is a judgment, Milord. I'll give that, Milord. I think that time to go.
I heard Mr. K. Chaudhary, the thinking by Mr. Irving on probation as a professor of community. Science at Kansari. Commissioner is agreed. In fact, Commissioner is agreed by the issued by Director of AIM.
Can I just show one thing here? So Lordship would kindly come to page 79. Authorization of Director, All India Institute of Medical Science to issue search sheet and statement of allegation, penalties, and suspension order for obtaining approval of the governing body. The
Who is
President,
for the-
All India Institute,
Who
as
is
the
for
case may be.
union? It's for the union here.
No, Milord, what I am saying is,
Ah.
in case there is authorization, then it must be shown that by the orders of the Board of Governors. That's what, Milord. The notice, charge sheet,
You
and
are reading
statement,
from page
page 79, Milord.
79.
Yes. One. Third line. The notice, charge sheet, and statement of allegation shall be signed by director for and on behalf of the governing body or president as the case may be. And documents shall also expressly state the facts. Phrases like by orders of the governing body or president. And kindly come to the impugned order, Milord. It is not there. Page 123. If he was authorized, then my lord, he should have written that. The manner is prescribed, it has to be done in that manner. It is by the respondent number 4.
So who's for the union here? I see respondent
Then-
one, the Union of India.
Well, like aims, they have their own set of counsel.
No,
They
no.
appear from case to case.
Respondent one is the Union of India.
Oh, Union of India is there. Yes, I can.
Petitioner is agreed by the show cause notice dated so and so.
Now, follow that.
27/7/2026. Whereby the petitioner was called upon to show cause in response to the charges, in response to the allegations made in the show cause notice.
Right.
Stop petitioner was permitted to submit her reply within a period of 7 days from the date of receipt of the show cause.
My lord, I got the judgment, Milord.
Counsel for the petitioner submits that as per the rules, these are the rules,
Yes, regulation.
regulations, as per the All India Institute of Medical Science. What are the regulations? Page
Yes,
number?
Milord. Regulation is,
All India Institute of Medical Science
yes,
rules.
aims regulation of 2019.
This is rules, I think. Page number 59.
61, Milord.
Aims regulation
61.
of 1999. Post of a professor, that the disciplinary authority for the post of a professor, disciplinary authority for group A posts other than the director is that of the governing, is the governing body of AIMS. Stop. submitted that post of professor is a group A professor, is a group A post. And as per the regulation 33, it is only the governing body, disciplinary, who is the authorized authority to initiate departmental proceedings and not the director. Stop. The learned senior counsel has further referred to footnote 1 of schedule 2, submit that in the event the director is authorized by the governing body or the president, then the same should be reflected in the order. So, the senior counsel submits that reading the show cause notice dated 27/5/26, there is no reference that the governing body had authorized the director to initiate the show cause notice. So, therefore submitted that the show cause notice, that the director is not authorized to issue the impugned show cause notice, and therefore the director having usurped powers not vested on him, the writ petitioner is not entitled to submit such unauthorized assumption of jurisdiction by the director. So, being agreed, the present writ petition is filed. Mr. Chaudhary also refers to the judgment of the apex court rendered
1993, 1 SCC 419, para 4.
1993.
1 SCC 419, para 4. My lord, I'm just reading it, my
419,
lord.
para 4, submit that in all cases, disciplinary proceedings it could be initiated by, maybe it could be initiated by an authority below
Other than appointing.
other than the appointing authority. However, when the rules are framed,
Yes.
then must be initiated as per the
By the prescribed appointing.
by the prescribed appointing authority as indicated in so therefore submit that without there being any reference that the governing body had authorized the director to issue the show cause notice. Director is not the authorized authority under the regulations to issue the show cause notice. Submits that the impugned show cause notice and the proceedings be interfered with and set aside, and the pendency of the writ petition, the further proceedings we stay. Para. Mr. Odikari, learned CGC, appears for respondent number 1 and submits that at this stage has no instructions and would like to complete instructions. He, however, submits that he represents only respondent 1. So, considering the submissions made and upon a careful perusal of the rules, the regulation, the AIMS regulation, say appended to the same regulation, it's clear that for group A posts, other than the director, the disciplinary authority is the governing body. So, perusal of the show cause notice by the director. The recital of the show cause notice, there is no reference that the director is authorized by the governing body. So, prima facie, it appears to the court that the show cause notice issued by the director in conflict with the procedure prescribed under the regulation 1999. So, therefore, that no issue returnable fix. Since Mr. Odikari pays for respondent number 1 notice. Steps on respondents 2, 3, 4, 5, 6 by speed post within 1 week from today. By the next returnable dates, further action taken against the next petitioner pursuant to the status. Is this matter?
The judgment para 4.
There are on 15th of July. In the right comes
My lord, the condor fault is reported.
What does it say?
The mark lot is given in the paragraph number 16 lot. Paragraph number 16 lot is the mark.
The judgment is silent about the preference part. On going to record, we find here the issue was whether nephew should be construed as a member. Sorry,
Nephew
member of the
as-
family. Because even division bench has said that family members cannot be confined to sons and daughters. It can include anybody. Even division bench has said. It the aspect of preference was not dealt. Because my lord, issue was whether nephew should be construed as a family member.
Para 18 it is referred to.
The thing is, my lord, they are supposed to frame a 309 rules as per the mandate of the Supreme Court judgment, which has not been done. Paragraph 12, the post of Gambura is an executive post in the sense that he works under the supervision of Mozadar. He holds a civil post and therefore is entitled to protection as provided under 311 of the Constitution. In that view of the matter, there has to be some service condition governing his service.
We come to para 20.
Pursuant to the aforesaid selection
No.
made by the selection committee, which had considered all factors and also the criteria laid down for purpose, the appellant was appointed to the post which came to be set aside by the appellate authority, which order was confirmed by the second appellate authority. Having gone through the records, we find that the first appellate set aside the appointment of the selection committee. An order passed by the subject officer on the ground that respondent one is entitled to preferential treatment, he being a nephew of the earlier Gaumura. We have found that the aforesaid view taken by the deputy commissioner was incorrect and without jurisdiction, and therefore the aforesaid finding, which are also rendered by division bench and also by the first appellate authority and the second authority, have to be set aside, which we hereby do.
But here in the case of Lordship, my lord, they are not in the preferential, my lord, that down. He is the son of my lord, S. Gaon Pradhan, my lord. My lord, only the mark, Lordship, my lord, I have, my lord, my question is only regarding the mark. That marks are not given to the, my lord, the private respondent. Hold on.
The view of the division bench was set aside.
Yes, my lord. But the
The
other
remand bench
division,
was-
other division bench is there, my lord.
Which other?
The single judge's order which was upheld by the division bench, I have given just
That
now.
is relied on Rajeshwar Das.
No, but this division bench order has not been set aside.
No, this is the Rajeshwar Das
No,
order.
Lord.
Lordship, Rajeshwar Das,
Rajesh-
Rajeshwar Das is separate. In Rajeshwar Das, the issue was, my lord, whether a nephew is to be construed as a family member or not. Division bench has also held that. Now, Supreme Court also held that. Here only, my lord, what had happened, the second appellate authority's order was set aside by the division bench. Now, here is a totally different, my lord. Here, the very simple issue is what meaning is to be given to the preference. Now, my lord, my learned friend is not referring to that particular clause in page 26, which I have read. That is the circular, that is the advertisement.
If you are relying on Rajeshwar Das,
No, my lord. No.
the fact that preference is to be given only when the base
Other things are equal.
other things are equal.
Yes.
That appears to have not been accepted by the
No,
appellate
my lord. No, that aspect has not been dealt with.
court. No,
No.
we says that the, kindly come to para 20.
Yes,
See, having gone through the records, there's
Yes.
somewhere about the third line, fourth line.
yes.
If you read further, the
Having
first,
gone through the records, we find that the first appellate authority has set aside the appointment of the and the order passed on the ground that respondent number 1 is entitled to preferential treatment.
he
He
being the
being a nephew of the alia Gaumura.
Ah.
We have found that the aforesaid view taken by Deputy Commissioner was incorrect and without jurisdiction, and therefore the aforesaid findings, which are also rendered by the division bench and also by the first appellate authority and second authority, have to be set aside, which we hereby do. That means, preference was given by the second appellate authority
set
as
aside.
well as by division bench.
Ah.
That has been set aside.
Set aside.
That has been set aside.
Right.
But division bench also held
Ah.
that the question of preference will come when other things are equal. And in the second case, my lord, if your lordship will kindly come, single justice here. I have already given, my lord. Please have that single judge's order. Please come to para 12 of the single judge's order.
Yes.
Kindly see paragraph 12, my lord.
I know, but on what basis?
My lord.
On what basis is
This
the
is not at this stage, my lord, I have some prima facie material to take support of my stand, my lord.
Lordship, my lord, my question is only, my lord, that marks were not given.
I'm reading in, my lord.
our view perhaps will not make a law unless we support it with reason.
No,
Then
my
why we are entitled?
No,
or-
I'm putting the things in perspective.
Ah.
Now, what does the advertisement say? Advertisement say, যে কোনোবা আবেদনকাৰী গাঁওবুঢ়াৰ পৰিয়ালৰ পৰা হয়, তেওঁক অগ্ৰাধিকাৰ দিয়া হ'ব আৰু এই ক্ষেত্ৰত মৌজাদাৰৰ সংশ্লিষ্ট মৌজাদাৰৰ views will also be মতামত লোৱা হ'ব. Let us translate it into English, my lord. Where does this marked business come? End of the day, that is the governing principle as to how a Gaumura will be selected. There, my submission is that question of preference will come only when other things are equal. This principle has been accepted by the Supreme Court also.
Yes.
So therefore, my humble
No,
submission.
we are only examining it from the point of Rajeshwar Das.
Yes. Rajeshwar Das, I was not aware of the Supreme
Rajeshwar
Court.
Das, whatever was stated,
Yes.
that other things with equal preference has to be given, was on the facts of the case.
It was on the facts of and that has been interfered with.
That has been interfered with. So
But the
now
other judgment is there, Miller.
the other judgment does not refer to any precedent as
No,
such.
I think it is there, Miller. Paragraph 12, which says, Miller.
It says, but
Yeah.
there's no reference as to why on what basis the conclusion has been arrived at.
Clearly, it is not there.
Lordship,
Anyway, since Lordship will be examining the matter, my lord, will protect my right during this period, my lord.
Parties. Interfering. Appellate authority in an appeal filed by the private respondent. Number 4, whereby the appellate authority allowed the appeal to bear with order or appointment of the writ petitioner as Gaumura of what was the direction?
Direction, my lord, my appointment has been set aside.
And then
And in view of selection of appointment Tarun Chandra Das, so is hereby set aside and quashed. That's all.
and the deputy commissioner Dorong
Take necessary action accordingly.
Necessary action. That this proposition is already by the apex court submitted that the question of preference which the first appellate authority held was not granted in favor of the private respondent, the appellant. Come into play marks obtained by both the candidates, namely the petitioner hearing and the private respondent number 4 as an first appellate authority, are equal. So, very other conditions of the marks are not found to be equal. The question of applicability, question of applying the preference will not arise. Support of this contention, reference to the judgment, judgment of this court, thus reported as also Rajali, it appeal number so and so, upholding the that the order of the first appellate authority be examined and interfered with by the court, and till the matter disposed of, adequate protection further submitted that as on date charge as the Gauhati of the same down plate and Mr. J. Hending, counsel appearing for the revenue on the other hand, submits that the allotment of marks is as per the notification. Notification. By notification or the advertisement.
The advertisement does not speak about any mark.
That is not been, that notification
As per the decision taken by the revenue department, and therefore there is no infirmity in the order passed by the appellate authority as in the column for preferential, the column for allotment of marks respect of candidates who belong to the Gauhati family or relatives of the Gauhati. Marks have been allotted to the private respondent. When on facts there is no dispute that the private respondent does belong to the family of Gauhati or is a relative of Gauhati. So, such circumstances, the first appellate authority prepared with the order of appointment of the petitioner and deputy commissioner law. Rendered by division bench is further appeal before the apex court, and the apex court by judgment and order dated so and so passed in Condorpo Horma versus Rajesh Das, reported in 2011-14 SCC 752, has interfered with the order of the division bench as also first appellate authority therein, and remitted the matter to the department for a fresh decision. So, submits that it is pursuant to the judgment and order rendered by the apex court in Condorpo Horma that the department has taken a policy decision to give marks or allotment of marks in respect of claims made by candidates that they belong to the Gauhati family or relations of the Gauhati, earlier Gauhati. Having heard that and counsel for the parties, perusal of the judgments pressed into service, seeing that in Rajesh Das division bench reported in so and so, categorically held that preferential marks are to be plotted when other conditions or other things are equal. The apex court in Condorpo Horma had interfered with the decision of the division bench in respect of finding of in respect of marks not being allotted to the appellant therein. Prima facie, it appears that finding of the division bench regard to preferential treatment, the circumstances under which the preferential treatment is to be given. Yes, to have not been implemented. There too. Judgment of the coordinate bench rendered in Rajan, WPC number 6774 of 2022, passed on 3008/2024, has also been upheld by a division bench of this court. Writ appeal number 53 of 2024. Stop. Such circumstances, prima facie, it appears to the court that conclusion of the first appellate authority that preferential marks required to be mandatorily given to the private respondent will require examination by the court. So, the argument raised by the learned state council that alternative remedy being available in the form of a review, the regulation 162D will not be a bar at this stage due to the fact that the questions raised in the writ petition will require interpretation in view of the judgment of this court as also the ethics court. Such circumstances, this issue returnable 4 weeks. Mr. Mendy accepts on behalf of the revenue department.
So 1 and 2.
1 and 2.
The lot. 1 and 2.
1 and 2. And who's for 3? And there's Golwa for respondent number 3. It says, extra copy will be furnished within a period of 1 week from today. Steps of respondent 4 within the high-speed course. Let this matter be listed on 15th of July. Till then, the impugned order of the first appellate authority shall remain stayed. You are asking for MSCP. Yes, sir. Notice at this stage. Yes, sir. Only notice.
Already, my lord, the point of maintainability on the ground of delay and HS and my lord, territorial jurisdiction has to be kept open.
Sir, MP, all.
Yes, sir.
Therefore, no. That's the point. Raise the question of maintainability of the ground of
Territorial jurisdiction and delay and latches.
delay and latches, then
Territorial jurisdiction.
why?
Rashmi, kindly see the order, my lord, what happened, my lord? Rashmi, kindly come to the area of respondents.
Mr. Khan.
All of them are from outside the state of Assam. And, my lord, the MSCP was denied by DIGP, my lord, Katgodam, Uttarakhand.
The MSCP claims for MSCP was denied
Yes.
by the DIGP
Yes, Katgodam, my lord, DIGP, Katgodam, Uttarakhand.
Uttarakhand. Therefore, submits that this court is not likely to entertain the writ. Question of maintaining left open to decide at the stage of entry. This report after the return.
My lord. Amen.
Very good.
Wait, wait, wait. This case, now 1 to 4 is already filed their affidavit. But I am applying for number 7. I need some more time to file our.
Yes. Counsel for respondent number 7. Mr. Raj Sharma, please for further 3 weeks time. File is come to affidavit, prayer made is not obtained. Step over after 3 weeks. Right. Yes, have you sorted out? Settled?
And
Is it settled?
and down.
Huh?
Settlement.
No settlement.
Talks are still going on.
Lordship, in this matter, so many long time has been taken and inordinate delay has been paid financial hardship to the British minor. Since last 6 years, not a single rupee has been paid in the first quarter of the farm, whereas the land belongs to the first quarter.
Why this IA has been filed? IA?
Lordship to appoint another arbitrator. They're not contending present arbitrator.
The arbitrator was appointed. Who was the,
Lordship.
by which order?
Lordship order dated 25/10/2014. The Motilal Dutta was appointed as an arbitrator with the consent of the respondent.
25?
10/2024.
In this petition, arbitration petition,
Arbiter.
where is that order? Where is that order? Page number? Arbitration. Where is that order?
Main petition.
We page number.
That order is not annexed.
You are saying that this order is passed in arbitration petition 6 of 24. What is the date of the order?
25/10.
25/10/24. Like the petition, who's the petitioner here?
Daniel Brown.
You are for the petitioner.
Petition.
So it is your prayer that we have appointed the arbitrator.
First.
Then
Lordship, the IA was filed by me.
uh, you are objecting to the arbitrator.
Yes.
How can you object now once you have not responded to the notice? You are represented before the court. You are for respondent number 1 and 2.
Lordship.
You are represented before the court. You are agreed to go and appeal. Go and file an appeal. What is the stage of arbitration now? Has he given a declaration? Has the arbitrator given a declaration?
No.
Do you have the copy of this order? 25/10. No. You go through the order, we'll take up again at, we are marking this for you. Read the order and come back at 2 p.m.
Lordship, any other day, Lordship, my senior is on leave on medical ground.
Your senior is leave on, we may not require your senior. You are good enough. Be available at 2 p.m. Please read the order and come back at 2 p.m.
I think it's the name the next week.
Who are you?
I'm the contemptor.
Huh?
The respondent number.
Respondent number?
representing the officials.
Uh, What is the stage of the review petition?
It is being,
When is
No.
it listed?
it was listed on March.
And when is the next date?
Next date, I have contacted the registry. Next week.
Let it be listed with the review petition.
After some time.
At 2 p.m. Come back at 2 p.m.
Filed an application for appointment of auditor. They have filed an application for impediment matter. I have filed my objection to them.
And the applicant in this petition.
What is your objection here? Well, you want to be impleted.
Impleted.
Why? Who are you?
Okay. This is the para number 2. They become a along with by the registered deed partnership number 22 January 1998.
Why are you reading? Why don't you tell us why you want to be impleted?
Please, Your Honor, may please read the deed annexure.
Annexure, page number
Page number 9.
9.
Here, I am the partner 3 and 4.
Partner 3 and 4.
4
Shankar Lal and Anil Kumar.
and Anil Kumar.
All right. Then
My lord, kindly see the page number 11. Number 2, the partnership is continuing. The partnership under this present shall be deemed to have into effect 22 day of June 1991 and same shall be carried until dissolved. And in number 5, that the duration of the partnership shall at will may be dissolved by any partner by giving not less 1 month previous written notice of his and intention to that behalf in such event partnership business shall not continue by remaining parties. But here we have not retirement or anything, but they have filed another in main arbitration petition in page number 17. Have filed a supplementary partnership bid.
page number
17.
17. 17.
Yes, 17.
Yes.
Here also
This is by 1, 2, 3, 4.
1, 2, 3, 4.
You are not there.
Yeah, no, yes, I am not.
Why is this supplementary? What happened to the, why is it supplementary?
I have filed my objection. I have stated that, my lord, subsequently, my lord, the constitution was changed, my lord. Parties were removed, my lord. They are not put to challenge the supplementary date before any other court, my lord. And they are not the party in this.
No,
case.
the challenge means, has it been registered? Have you filed an application before the registrar to say that these, because partnership will dissolve first, will have to be dissolved.
Or it may continue after my lord change of the constitution.
It will continue, but
Yes,
you'll have to go for settlement of the accounts. All these steps have been carried out.
And to my instructions carry out, and they are not put to challenge this partnership bid, my lord. They have come up only now, my lord. This partnership bid of 2023, my lord.
According to them, this deed does not exist. Is that what you're saying?
Yes.
But they are not
I am
put to
not-
challenge, my lord, to any civil court, my lord. This validity of bid, my lord. Their names were removed much earlier, but they are even by they are not in the income tax returns also. They are not in the bank also, my lord. Even they are not sought for implement in section 9 in Calcott also.
Where have you stated that it has undergone a change?
Lord, my objection, my lord, page number 17.
Objection. You are the
objection in the I-
petitioner.
I'm the petitioner for, I'm seeking appointment of arbitrator. Ma'am.
That's right. In the main petition, where have you stated?
In my objection, I have stated, impediment, my lord, I filed an objection, my lord.
No, in the main arbitration petition, that you have come before the court,
My lord.
and there was originally the partnership deed, and it underwent reconstitution. All these facts are, where have you brought in?
My lord, one fact I have listed there, paragraph number 2, my lord, that it was running since 1985, my lord. So running since 1985, paragraph number 2, my lord.
But there is nothing to say that it underwent some changes.
Because at that point of time, nobody was objecting, my lord. Since, my lord, my friend is there, he's the opposite party here, my lord.
I have there are 30. I have admitted the fact.
That has not been revoked. Okay. Paragraph 13.
Here it is.
Yes.
That in regard to para 16, 17, 18, 19, means of the petition, transferring, that initially by registered partnership deed number, let Devi Das Agarwala and let Amitan Agarwala and Vijay Kumar Agarwala Kamala, that thereafter by registered partnership deed number, dated 1990. Of MS Kamala, on and shall be deemed to have effect from 22. That is pertinent to mention here that both Sankarlal Agarwal and Kumar Agarwal, just Agarwala, they are Devi Das Agarwala are still alive, and there is no been filed by the petitioners regarding requirement of the partners Sankarlal Agarwala and Kumar Agarwala from the state partnership from by registered all the regarding the financial risk committed by me for adopting financial rights and liabilities.
But you are disputing the supplementary agreement, supplementary deed.
Because I am the living partner, the supplementary main business created by them.
In the original partnership deed, you are not a party.
I am a partner.
You are a party. What is your name?
My name is Vijay Kumar Agarwal.
Vijay Kumar Agarwal. Yes.
My lord, he is a partner in the partnership bid, my supplementary. He's not objecting. Now
He has raised an objection.
Raising objection before the Supreme Court will not nullify this deed, my lord, because they have to challenge before the court saying that this declaration is very void, my lord. They have not come to any court, my lord.
Oh, that declaration you have to.
Because I am not challenging it, my lord. They
You
are
may
challenging
not,
it.
but you have. Is it a registered deed?
Yes, my lord. Register partnership bid, my lord. For the
Both-
sub-registrar.
Huh?
For the sub-registrar.
Including the supplementary one.
Supplementary for the sub-registrar, my lord.
But in the face of this specific objection raised,
My lord.
that there is no such deed.
He is himself the partner. He has signed the supplementary deed. Now he is saying this is a void.
Financial
No. You see, you can't blow hot and cold. Parties being made arrayed as a party or not is a subsequent issue. You have raised the dispute with the very existence of the deed. Then how does it lie in your mouth to say that all of them should be made a party in reference to the supplementary deed, in which there is an arbitration clause? in which the petition 11.6 is filed, when your basic objection is that there is this deed is not, this is not operative in law. That is what you are stating here. Then
I am the sleeping person.
it may be sleeping partner, whoever may be doing, but either you say that yes, the deed is there and all the other necessary parties are required to be arrayed as a party, or you say that there is no supplementary deed. Yes. No, your prayer is there, but the question is that in the subsequent deed you are not a partner.
Yes.
And the where is the arbitration clause?
Page 20, my lord, clause 20,
This is in the supplementary.
supplementary.
Supplementary deed, there is a clause for arbitration. You are not a party. Then
But in earlier,
earlier deed has been modified by the supplementary deed. To accept the supplementary deed or not? No. Has it been challenged in any court of law?
No.
Then
Now, not challenge.
were an invitation by the court to go and challenge. You had entered into a deed.
Yeah.
They have now brought another deed saying that the earlier deed is modified where you are not a partner. Say that you are still a partner by virtue of the original deed. There has to be a decision by a court for which you will have to file.
Okay.
Have you filed any objection?
Till now,
Then why should we accept your submission that the supplementary deed is not valid without there being any finding? We are not the appropriate court to go on a finding.
next line, I am knowing that till fine.
And what about the opposite party? Your objection that all the parties are necessary, relevant if you accept supplementary deed. Maybe, but the partners have changed. Partners have changed.
He is the signatory of the supplementary deed matter. He has not objected matter at the time of filing the deed matter.
I didn't application. Present clause.
Heard Mr. Sra. Done it. Council at hearing notice. Chairman. Heard party number. You're not there in the
Yes, yes, I am the sole respondent.
the sole respondent. Party number 4. Yeah, number 4. Mr.
C Talukdar. C Talukdar.
C. Talukdar appearing for the applicant in alia-in-person. Petitioner was a partner. Where is the original deed?
Page number 9.
Is it there in the petition? No.
No, ma'am. Supplementary is
Original deed. Petitioner, partner, partnership under the name and style. The name,
Kamala Tea Processing.
Kamala Tea Processing Unit. Where is the name?
Ma'am, I'm coming. Page 18, my lord, Kamala Tea Processing Udyog. Page 18, the petition.
In the original deed, what is the name? The petitioner was a signatory of the deed of partnership executed by and between the petitioner and the other partners. By the deed of partnership executed on 22nd day of January 1998. So, the opposite party, sole opposite party, what is your name? The opposite party was also a signatory. The said deed executed by and between petitioner and the other partners on 22nd day of January 1998. So, subsequently, this deed came to be altered by a supplementary deed where partners, namely Agarwala and Pinto Agarwala, were no longer parties. So, petitioner and his own partnership along with other partners. Supplementary partnership was entered by and between the petitioner, the sole respondent, and other partners, running business under the name and style Kamala Tea Processing Udyog, having its head office with stopping and PSP. Shareholding of profits and losses were retained in the partnership at 25% each amongst the four partners. So, 20 of the partnership deed, supplementary partnership deed, provides that in case of disputes and questions in connection with the presence or the partnership property from a rights or credits or effects, matters can be referred to arbitration, single arbitrator. Parties agree upon one or otherwise to a board of arbitrators, one to be appointed by each party in the case of their disagreement, to an umpire appointed by the board of arbitrators. The claim of the petitioner that dispute arose, and in pursuance to the provisions of the party, and file resolve the disputes. Where is the notice?
Page 75, my lord.
And by notice dated
28/10/2024.
10/2024 of the party appoint concur appointment. There are three petitioners.
Three petitions.
Petitioner must be appoint concur on the name of the arbitrator mentioned. Say party failed to concur on the request made by the petitioner by the local agents. Had a reason, petitioner had also by filing the section 9 petition under the Arbitration and Conciliation Act. What order was passed? The case arbitration case number 01 of 2024 before the court of the district judge in India. Any orders were passed?
Yes, ma'am. But should sign the order, my lord, it says 57.
57.
57.
By the order dated 3/9/2024.
Yes, 73, my lord, the operating part, last paragraph. You've been allowed to run the print.
The interim protection was granted to the petitioners and the opposite parties, number 2 and 3. Who are opposite parties 2 and 3?
My lord, the branch manager, my lord, and that, my lord, present operates sole respondent here, my lord, Vijay Agarwala, and the branch manager bank.
Opposite parties to the section 9 petition, namely the present opposite party in the opposite party in the present arbitration petition, Sri Vijay Kumar Agarwala, and the branch manager of the concerned bank where the accounts were maintained, were directed to decrease the bank account number so and so, page 73 side over. Numbers so and so, so and so, so and so, and allowed the firm, namely Messrs. Gauhati Processing Group, to operate the said bank account through the partners either jointly or severally till the appointment of the arbitrator. Stop. In response to the section 9 petition, the opposite party also filed their objection. You filed your objection.
Yes, ma'am, page 78,
Was there any appeal against this order? Matter is pending.
pending.
And the matter is presently pending before the competent court of civil jurisdiction. There are under such situations, under such circumstances, present petition under section 11(6) has been filed, whereby the petitioners, who are the three other partners of the Gauhati Processing Group, has approached this court for appointment of an arbitrator. Where the opposite party has filed their objections and has raised a doubt on the supplementary agreement. Submit that said supplementary agreement where have you filed your objection here? Yes. That there was no document filed by the petitioners regarding the retirement of the other two partners, Sri Sankarlal Agarwala and Anil Kumar Agarwala from the partnership. It's constituted originally by deed number 35, dated 22/1/1998. Party therefore moved the objection that the subsequent partnership deed are void and cannot be acted such void document. During the course of the argument, the counsel for the opposite party has submitted before the court that there is no specific challenge made. A query made by the court. Supplementary agreement. signatory in supplementary partnership deed executed on Suez date. And therefore, by the opposite party will have to be overruled in the absence of any finding by any court of competent jurisdiction that supplementary partnership deed void and obligatory. Not valid in law. Correct. The partners of the original partnership deed, Sankarla, Agarwala, and names were supplementary partnership by virtue of the claim made by the petitioners that they had been retired. Kumar has filed an IA being IA number 53 of 2025 in the arbitration petition number, sorry, IA number 1713 of 25 in the arbitration petition number submitted that they are a necessary party present arbitration proceeding. Therefore, their implement as opposite parties in the present proceeding are vital. And of which effective orders in the not be and obligor or ought not to be issued. The IA, the applicant, they will be supplementary partnership deed executed by and between petitioners and the party. ID numbers submitting before that they had no knowledge of the same supplementary agreement, and there was decision taken for retiring the present applicants from the partnership. Therefore, the IA has been filed and they ought to be carried as partner respondent. Having considered the arguments submissions made by the partner and upon delivery of the meeting available, seen that supplementary partnership deed was signed by the petitioners and the opposite party, where names of the present applicants, namely Sankarla Agarwala and Anil Agarwala, are not reflected as partners. Yes, to have been registered before the registrar of partnership. There is also order passed by any court of competent jurisdiction questioning or interfering with the supplementary partnership on any point either by the opposite party in arbitration petition, applicants in IA numbers so and so. Such circumstance, prima facie, under such circumstance, so such objections have not been raised before the court. Number 9 of so and so is pending before the district judge. Yeah. By the present applicant, since state order and the petition are also enclosed. Yeah, present arbitration petition number. This court will have to accept such circumstances, the absence of any Yes. Questioning the legality, validity, supplementary partnership with dated so and so. This court has no option but accept supplementary partnership with dated. There are in better switch years reported in so and so. It has been clearly held that merely because petitioners, merely because one party has issued or called upon the other to the agreement, the other party fails to appoint or does not appoint the arbitrator. The right of the other party to appoint an arbitrator remains till petition under section 11(6) filed and notices thereon are issued by the such is presently filed on 20th December 2024. The
Ten to 24 months. Yes, 70.
7
28, 10, 2024.
75
Yes, 75 का notice.
28/10/2024, and the arbitration petition was filed on 20th December 2020. This is the matter 1/2025. Therefore, party have appointed an arbitrator as called upon till 2nd of January 2025. Having not appointed the arbitrator, now they are forfeited. They have forfeited their right for appointment of an arbitrator. So consequently, this court powers conferred under section 11(6) of the arbitration. Now past effective order. Denial of the pleading before the court is that supplementary pleadings line between the petitioners and the opposite party. Validity. Authenticity or the legality of the partnership deed has been questioned by the opposite party for the discussion made herein above. And in the absence of any specific orders passed by the court of competence, court will accept said agreement to be a valid agreement. That view of the matter. Therefore, to the point, as an arbitrator, as the sole arbitrator to decide and arbitrate on the disputes arising by and between the parties. So, make clear that the event, any of the parties place any order of competent jurisdiction in respect of the legality or validity of the supplementary partnership deed executed by and between the parties dated so and so during the course of the arbitration before the sole arbitrator appointed, then appropriate orders thereon shall be passed by the arbitral tribunal. So copies of these orders we mark to Justice Rumi Kumari Fukan, former judge of the Gauhati High Court, by the registry of the court. Stop who the prospective arbitrator will furnish a written declaration as required under section 12(1) of the Arbitration and Conciliation Act by the next date, pursuant to which the appointment made by this court will be confirmed. The parties are also permitted to place copies of this order before the prospective arbitrator appointed. Is this matter again on 24th of June? IA accordingly dismissed. The order passed. IA numbers 1.
Kindly see the last order dated 11/5/2020. Take complete instruction.
Any instructions?
That I have not received any instruction. I am told in the morning, I am Bhattacharya Madar Singh file Kalakama on behalf of the board. Be able to obtain instruction.
Where is M. Bhattacharya? Please inform her, take up at 2 p.m. 2 p.m.
There's a direction to appoint the petition on completion ground. The last occasion, Lordship had permitted them to do not complete the instructions and file their affidavit. If they do not do affidavit file,
Affidavit not filed.
no, my lord. The appointment order is under due process. I'm going for 3 weeks time to get the updated.
No, not like that. What do you mean appointment order is under due process? You are in contempt of a direction issued by the court.
Right.
Why 3 weeks is necessary? Why 3 weeks?
My lord, we have not yet received the instructions.
Huh?
We have not yet received the instructions.
Then why are you praying for 3 weeks time to implement without instruction? Get your instructions. We'll take it up on Monday. 15. Please inform your client that if the orders are not complied, we will be compelled to call them court on personal appearance. First on Monday, enabling the counsel appearing for respondent.
Respondent number 1, 2, and 4.
1, 2, and 4 to complete the instructions as to why the directions contained in the order dated so and so passed in WPC so and so not being complied with. Mr. H. Alia, IPS 4.
Correspondent number 2.
Respondent 3. Mr. Hendy. Mr. M. Doctor, Senior Counsel, assisted by Mr. L. Dekha, IPS for the petition. Monday.
Keep level.
Kindly see my lord, 14, offered with a second. Were rejected
Height, my lord.
Who is for the respondent?
I am appearing for respondent number.
A service report on respondent two is awaited. They accept, they accept. If they don't accept, can we force them? You are for
I am for respondent number one. I am for
one and three. Who's for two? You're not accepting on two. As per office note dated 3005/26, service on respondent number two is awaited. MSS Barua appears for respondent number one,
yes, sir.
and MS B Sharma appears for respondent number three.
For respondent number two, I can appear.
That's
Some
what we asked you.
Yes,
Are you
Lordship.
appearing or not?
Yes, I am appearing.
However, substance that can accept this on behalf of respondent number two. Therefore, extra copy will be furnished to Ms. Barua. This matter again in July.
I have received an instruction, Lordship. As per our instruction, Assam Rifles has no rule.
Huh?
Assam Rifles has no rule. Private
You bring it
agency-
on record, whatever you want. Got it. File an affidavit properly. List immediately after reopening. After reopening, make a mention in the word.
Okay.
Have you seen the order?
Lordship.
Now, after that, what happened? Has he furnished any?
Lordship, there's some form of the contacting lawyer, but
Declaration form.
He's not given. He's not given a declaration.
he only submitted to like our
Lordship, they are only challenging the selection of the arbitrator. It would only be fair if there is a mutual arbitrator handling the matter.
Your challenge is already gone. There is an order passed. Have you filed an application for recalling this order? Then
Lordship, the order was passed the same day the arbitrator was selected, your lordship, by this court. So after that, we filed.
you were
I-
represented.
Sorry.
You were represented. Your
Yeah.
counsel was heard. Then, if you are aggrieved, you have to take steps. When can you file the? Within 3 days. Friday.
right.
Friday you can bring it. Or at least this matter on Friday. As it is submitted by the counsel for the petitioner that the pursuant to the orders passed by the court appointing the arbitrator, the written declaration was furnished to the counsel who has not been able to place it before the court. The counsel therefore submits that matter is listed on Friday, which is 5th. He will be able to submit the same written declaration. Accordingly, list again on Friday. Yes, Friday.
Maybe check along with the content.
Submitted at the bar that review petition has been preferred by the respondents by the fishery department.
Yes, lordship. Sir.
Fishery department in respect of the order dated 6-9. Is it 6-9?
Yes, no. Yes, sir.
6-9-2024 passed in WPC number 3182 of 2023.
39 of 26.
Accordingly, the contempt petition be connected with review petition 39 of
26, Lord.
26. Listed after 2 weeks.
And can a date be fixed?
On a date to be fixed by the registry after 2 weeks. It will be listed.
Lordship, this contempt is filed against the order dated 29. I'm representing in the contempt, both the contempt. Yes. The contempt petition, I'm representing both the contempt.
Mr. P. Sharma, learned counsel, represents the respondent in the contempt petition.
Highly of that. So this date is 28/9/2020. Order which has been.
After 2 weeks, it will come.
No, 28/9, Lordship. Date of this order, which has not been followed by the respondent office. It's page number 26, Lord. 6/9.
26.
6/9. Page number 26.
26.
6/9. Oh, yes. 6/9. It's okay. Here, already right. Okay.
But ultimately, I will have to take instruction of the executive officer. A letter was sent on 1st of August 2025. Another was.
No, you mentioned that your colleague is
Yes, yes, Madam, yeah. I told her, Madam, that they have discussed this, Madam. But we informed you the moment. Anyhow, Madam, some time may be granted, Madam, I will take.
Notice was issued 28/7/2025. Dusty accepted on 7/8/2025 and postal delivery on 19/8/2025. Principal board, that's one number 3 and 4.
You undertake to obtain instructions.
Yes, I will have to obtain instruction, Madam.
From respondent number 3.
3. Not 3, Madam, 4. Executive officer.
Executive. All right, that is 3, 4 is. You are representing 4.
Not 3. 4, yes, yes.
3 is the board.
Board.
My senior colleague is on executive officer.
Of the same board.
Same board, same board.
Maybe same board, Madam, time we can accept notice on behalf of the.
Mr. H.K. Sharma appears for the petition and Mr. T. Sutia appears on CD. Respondent 1, 2, and 4. By the earlier order dated 11/5/26, ordered that if none represents respondent 3 in spite of service being complete, matter will proceed ex parte. From the records, it is seen that service is complete on respondent number 3 as per office note as per Lozima Court order dated as per office note dated 13/2/2026. That apart, you have taken Dusty.
Yes. Dusty.
Service by way of Dusty was also effected on respondent number 3 and an affidavit on 7/8/2025 and an affidavit to that effect has been filed by the petitioner on 21 August 2025. Under such circumstances, matter will now proceed ex parte against respondent number 3 as none represents the respondent 3 in spite of service being complete. Whereas Mr. Sutia, on the other end, submits that he would like to complete his instructions from the respondent, including respondent number 4. Praise for
1, 2, and 4.
2 weeks further time. Date may be given. Please this matter again after reopening.
Yeah.
After reopening. 15th July. 15th of July. By which time the respondents are expected to complete their instructions as sought for.
Deeply obliged.
Petition. Order document find page 16. And operative part is page 28. Regarding document directed for payment of
Why not
revised
comply?
pay.
See, we have filed a affidavit, Lord. For the respondent. Here the direction has been issued to the Hadi board, what is Hadi board, Lordship? We have filed a affidavit, Lord.
For Khadi board. What is your instruction? Your finances filed affidavit.
Yes, Lord. We have filed a.
When? Not available here.
Yesterday, Lord.
Mr. H.K. Sharma for the petitioner, Mr. H. Aliha, counsel appearing for respondent number one.
One.
He submits that affidavit has been filed yesterday. So, although stated that the affidavit was filed yesterday, copy of the same is not connected to the case report. Registry will place out the affidavit stated to be filed yesterday and connect the same to the case report. But Mr. Banerjee for respondents 2 and 4, Mr. E. Gayan for respondent number 3.
So respondent number 2 will also have to clarify their stand because they are the secretary, they are the government.
The respondents are permitted 3 weeks further time to complete their instructions and file necessary affidavit. Based again on 15th of July.
Before vacation.
No, after the
After vacation.
let them file their affidavit. 15th of July. And appears for the petitioner on call. Again next week.
Challenge the termination order, contractual employee. On the, our intention is that principle of natural justice has not been followed. No suppose it was issued. And the order,
You are permitted to bring certain documents.
yes, we have annexed also. We have submitted additional evidence.
When did you file it?
My lord, it was filed on February 2020. This is the
Not available.
The font starts from page 15. Page 15 of the running page.
It's not available.
File.
We have filed, but it is not here. In deference to earlier order dated 28/5/2025, counsel for the petitioner submits that he had filed an additional affidavit to bring on record a relevant document pertaining to the terms of the contract relating to the petitioner's engagement. Stop. The affidavit was stated filed on
February, my
the month of February. However, the state affidavit is not available in the case report. Please free to verify in tracer. the affidavit stated to have been filed and connected to the case report. Mr. Mohan, Mr. Lady,
All the
all the respondents. List accordingly after 4 weeks.
obliging.
Modification lordship, and that inadvertent mistake from our side lordship. In the whole read petition, including the synopsis, we have well pleaded that representation dated 29/8/25 to be taken into consideration. But in the prayer portion, it has been mistakenly some other date has been inserted, lordship. And if your lordship comes to page 16 of the read petition,
No, what is the correction in the order?
that only the date,
What?
that place of this along with 15 is 29/8/2025 representation. Only that is.
But also 15/26
That is after the
Yes,
advice.
it
After
was
it
against
Is it not enough to say that this representation should be disposed of? Why you want both the
Yes,
representation?
that is why we have come to put this on the board. In fact, that was the whole purpose of filing the petition. What has happened, we have pleaded lordship that IO has proved out of the 4 charges, where the heinous charge was that sexual assault, that has been disproved, and other two has been disproved, 2 has been. Thereafter, for tentative agreement, it has been forwarded to EPSC. And lordship, if your lordship comes to the interlocutory application, this first
I have not understood what is your prayer. What do you want?
my prayer only to take into consideration that my representation
Which representation? They did what?
dated 29. That
Where
is
is it?
with the interlocutory application.
Where is that representation in your writ petition?
That was the mistake, lordship.
It is not enclosed.
We have yes, lordship. I like to place in the read petition para number 26.
Oh.
May I allow to read that para? So page 16, para 26. That the petitioner further begs to state that it is apparent on the face of the record that the petitioner had in fact submitted a detailed final representation dated 29/8/2025 on the IO report and the PDN, traversing each of the 4 articles of charge in elaborate detail. The said representation appears not to have been placed before the Honorable UPSC, as it is evident from para 4 of the advice, which records that the CO did not submit any representation. The DIG so-and-so signal dated 7/10/2025 calling for a translated copy of the defense exhibit duly furnished on 8/10/2000 is independent confirmation that the said representation was very much on record. A copy of the said representation dated 29/8/2000 is again enclosed here with for ready. So here we have done the mistake, lordship. We have not annexed that. That is because of the bulky nature of 1000, and maybe that has been this is the representation of 1000.
Where is the representation of 15/5?
15/5, no dispute regarding
Where
that.
is the page number?
Page number on other day she has this page.
Where is 15/5?
Page. That's from 49 on. The advice, lordship. We are not, that is not regarding 15/5 is after the advice. Before advice, there has to be a representation. That has not been, and this will confirm by their own letter, lordship, in the interlocutory application at page 22, lordship, page 20, page 19 is in the interlocutory application, page 19.
So the order said there is a application dated 15/5 filed by the petitioner. The order says 15.5.
this Lordship's order, that because of our mistake on the Lordship.
Lordship,
That is because of our mistake in the prayer portion, we have pleaded, we have wrongly mentioned 55 instead of, in the whole petition, we have pleaded about 29.8, but in the prayer portion, we have done mistake that 15.5. That is the mistake on our part, Lord.
What is 15.5?
15.5 is another representation after the advice. That is not disputing. That is not disputing. This has not been, Lordship, in the interlocutory application,
You want consideration of which representation?
29.8.
So you come to page number 149.
That is 15, along with 15.5 is already after the advice. Before the advice,
Why don't you come to page 149?
140.
You come to the second paragraph. You have already referred to the representation 29.8, making the statement that it was already on record.
That is not. This paragraph 4 of the Indian Service Commission's advice, Lordship, that says that placing that Lordship, kindly come to page 130. Advice of, it starts from page 130. The advice of UPSC starts from 130. Now page 133, Lordship, their advice, page 33, para number 4, Lordship, may I please? The commission note that on denial of charges of NOCO, the matter was remitted for departmental inquiry. The IO in his inquiry report dated 6/1/2000 held article of charges 1 and 3 as proof and article of charge 2 and 4 as not proof. DA tentatively disagree with the finding of the IA and held all 4 articles charge as proof. DA forwarded IO report along with disagreement note to the CO filed later dated 4/7/2025 for his representation. If any, the CO submitted letter dated 30/7/2025 and 18/8/2025 requesting extension for time till 28/2025 for submission of his representation. However, did not submit any representation. That is my case. I submitted the interlocutory application containing the page number, Lordship, 20, page number 20. Page number, if your Lordship come to the locatory application, it's 29/8/2025.
What order do you want now?
Only the state to be this representation 20 instead of along with 29/8.
That is what I'm trying to tell you, that in your page 149, in the representation dated 15/5, there is already a reference of the 29/8/25.
That is my representation. I have referred, but while showing disagreement, they say that there is no representation prior to the after the notice. I did not send any representation, and that was not replaced. And the last page 22 of your Lordship's interlocutory application. Kindly peruse that for a moment. That whether this has been officially forwarded even. Lordship, kindly page 22. Lordship, interlocutory application.
What correction you want?
Only that date.
No, only the date is not possible. You read para 6 of the order. Read para 6 of the order by which your writ petition was disposed of.
Lordship, that is Lordship, my whole
The
petition.
direction is to the respondent number 2. Who's
No.
respondent 2?
Lordship, my entire petition, this writ petition was about this representation, consideration of representation dated 29/8/2025. But in inadvertent mistake on our part, we have this seeing the bulk nature, maybe this has been deleted, and prayer portion also 15/5.
This 29/8 is representation to whom?
To the department.
the department.
to the department.
Huh.
That is only, that was the whole purpose of filing this writ petition, Lordship.
So what is wrong in the para
That-
6?
that- Lordship, we have erred in mentioning in the whole writ petition, and I am reading the synopsis,
No, no.
Lordship.
You want the department to consider that representation.
My 29A, that nothing else I want, Lordship.
So in your 15.5, you have already referred to this.
But
So there is a direction to consider your representation dated 15.5 means the prayers made in 15.5 will have to be considered, which includes your prayer for consideration of the representation dated 29.8.
Lordship may kindly add for ends of justice, Lordship. Because if not, it's placed by my entire, then this, even though the heinous crime which has been disproved, that will be proved by the UPSC, Lordship. My stand will be taken into consideration. Only that to the
Then you are asking for a review of the order.
No, I'm not, just to add, because my repetition was all about,
Maybe all about, but we have passed the order in your presence.
Yeah,
You
Lordship.
agreed to this order. Now this
Because
particular,
not seeing that annexure,
no,
Lordship.
merely putting in the date is not going to carry any meaning. The direction of the court is to the respondent number 2 to take into consideration the representation dated 15/5/26 filed by the petitioner. Right? 15.5 reflects the representation dated 29/8/25.
This observation may given, only this observation. This
Why the observation is necessary when the
Lordship, it's
15.5
been
representation
necessitated, it's been
contains?
necessitated. That's why we are,
Huh?
we are before your Lordship.
Who has expressed this necessity?
It is because since this has not been that the UPSC advice clearly I have shown, Lordship. Page 133 says that I
Yes,
have not submitted.
Yes, CGC, what do you say?
Only this much, Lordship.
She has already submitted her final representation, Lordship. In the representation, it is mentioned.
You mentioned there.
Lordship, it is
Therefore-
mentioned, but that with those charges, those all things left unrefuted, Lordship.
So when this.
We are not expressing anything on merit. That's what the order says.
Yes, Lordship. Only to add along with 15.5, 29,
So
8 to be taken into
29.8 is already mentioned in your representation dated 15.5. So 15.5, if they have to consider, they'll also have to look into 29.8 as per your representation. Why do you want another order that this representation should be considered?
Actually, Lordship, we did mistake in the prayer portion. That is the main conflict
We
of.
don't know.
That
Now,
is why
if you
that is
think
all
that
inadvertent mistake
whatever
from
it
our
may be,
side.
if you want this to be included in the prayer portion, you have to go for an amendment. Now the petition is already disposed of. So we'll have to recall this order and then you pray for amendment.
That will be a longer process. In the
Then-
meantime, the whole only to include
I don't think there is any prejudice cause because 15.5 refers to your 29/8/2025.
Lordship, may I pray for ends of justice. This simple observation will suffice the entire fact. My this interlocutory application be disposed of only with this observation, Lordship. This much, Lordship.
What do you say?
This much only, Lordship. I am not asking for anything on merit, Lordship. This much. Let them consider after that whatever the result.
Where is 28.5? 28.9? 29.
Interlocutory application, Lordship.
Where is 29.8?
29.8, that is page 21 of my application. And they have
You
received,
have not enclosed in the writ petition.
that has been skipped. That is a mistake, Lordship.
Number.
Page number 21, Lordship. My representation. And this has been communicated. The next page will confirm that this has been communicated by the office, by the respondent office.
We'll have to recall this order. It will carry no meaning like that. your application is not a part of the main writ petition. We have disposed of the writ petition with an order.
Not right.
And this,
See, for only to that effect, Lordship, that already it is there.
You're not understanding. See, you say that it is for ends of justice, but it was injustice because this document on which you want a direction was not a part of the writ petition. You want to bring it, you bring it by seeking amendment. Otherwise,
That is
in
why-
the representation which was directed to be disposed of, there is a specific reference of this particular representation which you now want to refer to in your IA. So, needless to say that disposal of the representation directed in the order of 15.5 will mean that the authorities will also have to take into consideration your representation, that is 29A, because it is referred in 15.5.
His observation knows the idea of his observation. With this observation, that already there.
I heard MST Som Learned Counsel to the petitioner. The petitioner by WPC 2805 had approached his court praying for a writ. Set aside and quash the PSC advice F number 3/222/2025. So and so side over page 24. And also accept the final representation of the writ petitioner dated 15/5/2026 against the advice of the PSC. So, submissions made by the court, before the court, by the parties, writ petitions to disposed of by order dated 29/5/26, where at para 6 the following direction was issued. Para 6 court. The petitioner has now come up with an IA, being IA number so and so, seeking a further direction that the authority should be directed to dispose of the representation, earlier representation dated 29/8. (29/8/2025), which was filed by the petitioner earlier. It is submitted by the counsel to the petitioner that by oversight, this particular representation was not enclosed to the writ petition and specific prayer thereon also were not included. Therefore, prayer is made by the IA seeking an seeking modification of the order dated 29/5/2026. Direct the respondent authorities also consider the representation dated so and so, which is now being sought to be brought before the court by the IA. Para MSR Devi Learned CBC submits that the representation dated 15/5/26
Yes.
refers to the earlier representation dated 29/8/24, 29/8/25. And the court had disposed of the writ petition without expressing anything on the merit, the direction as specified in para 6. Therefore, at this stage, prayer made in the IA ought not to be allowed. Having heard the counsel to the party, having noticed the orders passed, and seen that in the representation dated 15/5/25/26, there is a specific reference made by the petitioner with regard to his earlier representation dated 29/8/24.
But a
25.
page 374, there is also a prayer lordship, they are represented regarding this consideration of representation. Page 370. Therefore, lordship, for it order.
representation
by the petitioner against the advice of the APSC.
dated
15-5.
15/5.
15-5. This is the prayer portion 374. First prayer is
The representation reflects that there is a direction, there is a prayer before the authorities to take on record the reply representation along with the commanding officer's final, along with the charged officers, that is the petitioner's final representation dated 29/8/2025, and consider both while taking the final decision in the matter. So, under such circumstances, since by the earlier order dated 29/5/26, the writ petitions to disposed of in terms of the direction issued in para 6 without expressing anything on merit, it is needless to say that the respondent authorities, while disposing of the representation dated 15/5/26 as directed, will take into consideration the issues raised in the said representation, the earlier representation dated 29/8/25. Under such circumstances, there is no merit in the IA. IA accordingly stands dismissed. The order dated so and so passed earlier in the petition stands reiterated. Disposed. The order passed today will be read together with the order dated so and so passed in WPC. Disposed.
I'm so grateful.
Dismissed.
Presentation was rejected. The simple ground, my lord.
Where is the transfer order?
Transfer order, my lord. Annexure. Page number 19 now. Annexure 1. Page number 4, my lord. Additional commandment. Place the present place of posting 40th Battalion Varsat and the next frontier headquarters SSB Gauhati on west without PPE and JP. Thereafter, my lord, he was again posted, that is annexure 3, page 21. That is the type copy, my lord. So frontier headquarters Gauhati to 68th Battalion Devendra Nagar. After 68 days, my lord, he was posted from Devendra Nagar. Then after, my lord, he has submitted the representation. Presentation is at page number 28, my lord, annexure 7, and relevant page portion is at page number 29, my lord. 29, my lord. Second last paragraph, my lord. Further, it is not out of place to mention here that I was transferred from 63 Battalion SSP to Frontier Headquarters Gauhati on own request without PTA and joining time. But Frontier Headquarters has again transferred me from Frontier Headquarters Gauhati to 68 Battalion SSB with a short span of, that is, 2 months and 8 days in public interest. So treating my transfer order dated so and so from 63 Battalion to Frontier Headquarters SSP Gauhati on own request without granting me PTA of the joining time is not justified, as I failed to fulfill my purpose for which transfer was sought by me at Gauhati. This representation, my lord, rejected
only on the simple way, my lord, that is lecture 11, page 33, my lord.
What does the rule say?
Rule says, my lord, the tenure of the transfer, my lord, kindly come to page number 37, my lord. Page number 37, serial number 5, my lord. Tenure of the posting. Yes, this is the posting policy, tenure of the posting, normal tenure, my lord. All units and formation, 3 years, plus 1 plus 1. That is that sentence.
What is this 1 plus 1?
1 plus 1, my lord, it can be extended for another 1 and 1. And the rejection of the representation is, my lord, as case number 33.
No, regarding TA,
My lord,
what is the rule?
my lord, if I was posted on my own request, my lord, that traveler council can I was
So you went from Gauhati at your own request.
my lord. I have not completed my tenure in Gauhati, my lord.
May not be.
Yes, my lord. That's why my own
Now
request-
from the for the subsequent transfer, you're getting your TA.
subsequent transfer, my lord, I have got my
Uh,
but and I was posted from
on what basis are you asking the TA now? When
I'm not-
we
I'm
don't
not-
dispute that it is on your own request.
I'm not asking that.
Hmm.
I'm asking that posting I came to party on my own request. It's maybe treated as a public interest.
That is why, because you want the TA.
My lord. And option of the
But the
own
fact
request,
is that you had requested for transfer on your own.
I have requested, my lord, but
Ah.
I have not completed as per policy.
You may not have completed, so. But does it nullify the request made on own request?
My lord. As per policy, my lord, yes, maybe it as Gauhati, my lord.
Under what rule, what office memorandum are you claiming that the transfer on own request would not be completed as per your tenure? Therefore, it is to be treated on public interest. How is it possible? You had approached the authority. They agreed. Then they decided to cut short the period.
My lord.
Huh? Does it make it transfer on public interest for that particular sector? You were transferred from A to B.
My lord.
You sought transfer from A to B on own interest.
Own request for 3 years now.
For 3 years, 4
Fine.
years, whatever it is.
My lord.
Before the end of the tenure, you were transferred from B to C.
My lord.
Yes? For that is on a public interest.
My lord. That
You are entitled to all the allowances into the ADA.
my lord.
Right? Now you want to say that because you sought for transfer on own request from A to B, and that tenure was not allowed to be completed, it should be treated as public interest. On what basis? Huh?
Then I will place instruction.
There is no instruction. What instruction will be placed other than what is there in the petition? On what basis? You are dismissing your petition. No ground.
Everything is I don't have
What instructions is on your basic case before the court is that
my lord.
without instructions, how will you file the writ petition?
But I will next week, my lord.
Not next week.
On Friday, my lord.
Not Friday.
Friday I will take on Friday.
Counsel for the petitioner seeks liberty to complete his instructions in the matter. List again after 4 weeks. Mr. U.K. Goswami, learned CBC appears for the respondent.
Item 26, my lord, notice was issued on 21st March 2025, my lord. Affidavit in opposition has not been filed.
For the respondent, Assam Rifles,
My lord.
B. Sharma. Where is B. Sharma?
That, my lord.
Matter is listed after the returnable dates. Stop. None represents the union. The earlier date, MS B. Sharma. Then at CGC represented the union. No affidavit has been filed.
Okay.
You are for B. Sharma.
A guy.
When B. Sharma's name was recorded earlier, it's submitted that MS E. Gayan represents the respondents. Submits that instructions are not complete, list again after 4 weeks, by which time the respondents are expected to complete their instructions and file any affidavit if so desired.
Pending the last time. Last time it took time, 2 weeks time. I've sent already, it is prepared, madam.
This time you want 3 weeks time,
Yes, madam. 2 weeks, madam.
2 weeks. Mr. S.K. Medi, learned CGC, renews his prayer for further 2 weeks time. Prayer made is not objected to by the council. List again after 2 weeks, 3 weeks.
I know. I know.
Matter relates to
Promotion,
promotion. Yes, the respondents.
Hearing your lordship, some time may be given for filing a
Mr. M.K. Bora for the petitioner, Mr. K. More additional appears for the Panchayat and Rural Development. Petitioner claims promotion to the post of
assistant.
Assistant Engineer, Panchayat and Rural Development. Let the pleadings be exchanged, matter be listed after 4 weeks. Online.
My lord, the pension matter, my lord, notice was issued on 14th by 2025, my lord.
I have received the instruction, we are drafting the affidavit, my lord, 3 weeks, my lord, I'll file my lord.
Mr. K.K. Parashar, learned CGC, submits instructions have been received. Like to file the affidavit, he prays for 3 weeks time. Prayer made is not objected to by Mr. Kumar for the council for the petitioner, list after 3 weeks.
Contractual employee, my lord, on the ground that arrest by the police, and this matter is already decided by the honorable court, executing order and the order. Now today. Affidavit, my lord.
M.J. Khadir for the petitioner, M.S.A. Bora for the NHM. Bora submits that affidavit has been filed today and copies have been served on the respondent, on the petitioner. You want to file your objection? What is your prayer here?
Where, my lord, the impugned order is stigmatic order, my
No,
lord.
what is that impugned order?
My lord, impugned order.
Is it termination?
Termination.
The matter be listed. Let it come in July. Matter be listed.
Judgment, my lord. Court judgment is there, my lord.
Where is the judgment?
Judgment, my lord, I have a copy. Judgment. Found by the
It is submitted that the petitioner does not wish to file any rejoinder. Accordingly, let the matter be listed on 17th of June.
Based on an approval of Constable PD, my lord, the certificate as required, my lord, and OBC ancestral certificate, my lord, as required in the advertisement, my lord. But their certificate was not considered, my lord, and petitioner was treated under general category, my lord.
When did you produce it?
At the time of document verification,
When?
it was took place in November 25, and month of November 2025.
November 25. What was the cutoff date?
Cutoff date was, my lord, and this is, my lord, case. $5 million. Case 20. Cutoff date was 14/10/24. My certificate, my lord, fine. Case 45. Certificates, my lord. One is case 45, my lord.
How can you have two certificates?
After that, my lord, subsequently issued by the.
But how can you have two certificates? Why? You have already got one.
For different year, my lord. This one, my lord, 3/10/24, my lord. Case 45. Cutoff date, my lord. And for subsequent year, my lord, that is case 46, my lord.
This is dated what?
This is
310.
3/10/24, my lord.
310. And the other?
Other is, my lord, case 46, 37/25.
Why this certificate was required? Why in 37 you have taken another certificate?
For the year 2025, my lord. If we have the certificate is by the authority.
Huh? Huh? No, as per the advertisement certificate, for which year is required?
Certificate is 45, my lord. 3/10/24.
Therefore, we are asking you, is it for a subsequent selection that you have taken out a certificate or what?
Selection was made in 3 year, my lord. So
Ah.
petitioner also collected certificate, my lord. At the time of document, he had both the certificate. Accordingly, he put both the certificate.
Then what was the rejection order?
Not to have been produced the certificate of case 46, my lord.
Huh?
He ought not to have produced the certificate of case 45, my lord, 46, my lord.
Ah.
It was not required actually.
Ah.
He was only required case 45 certificate.
So what was the order passed?
No order passed. At the time of my document revision, his candidacy was not rejected. But while the result was declared, my lord, the petitioner was not selected despite he got the cut-off mark for OBC category.
Yes.
Lordship, instruction not yet received, Lordship. And it took time, Lordship.
In spite of notice being issued on 9/2/2026, counsel representing the respondents renews a prayer for further time. The claim of the petitioner is that on the date of document verification, he was in possession of a validly issued OBC
NCL certificate.
OBC NCL certificate from the concerned authority by the certificate dated 3/10/2024. stop, he had produced the certificate before the authorities, along with a subsequently obtained certificate. However, although his candidature was not rejected by the respondent authority, no further orders were passed. Being thus situated, he has approached his court. Well, the CJC will apprise the court on 17/10, 17/6, as to whether the petitioner's case can be considered for appointment on the basis of the certificate, valid certificate produced by him. Based on 17/10,
17/6.
17/6.
Dear please, Your Lordship. Lordship, in this matter, the petitioner has retired on superannuation, Your Lordship, on 31/5/2026. So we need some time to get instruction, obtain instruction from the client, Your Lordship.
It is submitted that the writ petitioner, during the pendency of their writ petitions, has demitted office,
Retired on superannuation.
superannuated. Counsel for the petition, he is asking for what? Promotion,
Lordship, for finalization of gradation list, Your Lordship.
for promotion. Therefore, the counsel for the petitioner seeks liberty to complete instructions as to like further in the matter. Release this matter again after reopening of the vacation. Mr. Rai Bothakur for the forest. Mr. T.J. Monto, senior counsel, assisted by Sharma for respondent 7 in APSC. APSC. And Mr. Dr. Todi for UGC. UPSC. Again, the one who like on a date to be fixed by the registrar. Right.
Nothing remain. Already is various rejected by the government. That order is not fixed.
Has he been furnished with a copy?
Yes, Parrot, the copy is marked speaking order. I can give it to the council.
In July.
Suspension matter, Lordship. Inquiry has already been over, Lordship. Inquiry report has also been submitted. One interim order is there not to proceed with the inquiry any further. Lordship, I am appearing for SCR. Lordship will allow me some time to file my affidavit.
The case of criminal proceeding and
As well as
department
the departmental proceeding inquiry report has already.
submitted. On a day when the interim order was granted, the inquiry report was already submitted.
Yes, report out for.
The Nayak is waiting for the state. Submit said you'd like to go further instruction on the matter. Query against the writ petitioner has been completed and the inquiry report has been submitted to the disciplinary authority. Praise for 3 weeks.
3 weeks time.
3 weeks time, Mr.
I'm appearing on behalf of my
Mr.
senior.
So-and-so appears on behalf of the Mr. V. Rajwa. This after 3 weeks. Yes.
In this matter, Lordship, other side has filed their affidavit yesterday, Lord. Probably it is not in the record, Lordship. We have been furnished copy, Lord. Lordship, I'm praying for 2 weeks time, Lordship, in this matter to file one result.
Mr. P. Nayak, counsel representing the writ petition, submits. The respondent filed their affidavit yesterday.
Pardon, copy yesterday.
And copies have been furnished. You would like to file a rejoinder affidavit, prays for 2 weeks time. List again after 2 weeks.
Not
Meanwhile, the registry will also trace out the affidavit stated to be filed by the respondent and connect it to the case report.
Date may be changed. Then it could be 22nd.
Second is the last working day, last working
18th of-
week,
18th.
18.
Of that. Day on day.
35.
35 years.
More than penny.
So number one, filed their affidavit, right? However, I also wanted to know the stand of the government. Stand of the government for respondent number. Respondent number 2, 4, 2, 3, 4. They were directed to file their affidavit, placing their stand. Because respondent number 1 has admitted that the petition was titled and their area salaries and retirement benefits. But they pleaded that they don't have fund. So in view of that, this honorable court directed the government to place their stand.
Affidavit not filed.
Not filed, only by the respondent.
Yes.
I am appearing for respondent number 1 and our affidavit has been filed.
Respondent 1 is filed.
Yes.
Our respondent had seek time. The last.
Who's for the state? Mr. Sutia?
Fact, man, of page 75, additional deputy commissioner Dibrugarh Manot wrote to the Manot chairman Dibrugarh Development Authority on 17 February 2021. Manot secretary Dibrugarh Development Authority employed for regarding release of unfit price of his staff and connection you were requested to do the matter and take the action. So they will do chairman development authority. So it's
Do you want to file affidavit or not? That's a simple thing we are asking.
We'll find money.
Mr. Who lost for the petitioner? Mr.
I am for respondent number
Mr. Sutia appearing for respondent
4, 5 and 6.
4, 5 and 6. And Mr.
Polita on behalf of IV Hussain.
Polita on behalf of
IV Hussain.
IV
For
Hussain
respondent
appears on
number
behalf of respondent 1.
3 is the finance department.
Respondent 1 has filed the affidavit. The other respondents are permitted to file their affidavit if advised within 3 weeks, just after 3 weeks.
So date may be given.
On a date to be fixed by the registry.
Thank you.
Your Lordship, I am appearing on behalf of Mr. G.N. Saibala for the respondent. It is prayed that the matter be referred to mediation for settlement between the parties.
Mediation.
Earlier, we had a discussions, but we could not come to a consensus because the parties are from Tezpur, Nagaon. So let us try it mediation. As per their suggestion.
This is an application for appointment of an arbitrator.
Lordship, we are on that, but since they have requested only that much, otherwise we place.
We are not stopping you from going on mediation. Go to mediation, but it's an application for appointment of arbitrator.
Got it.
What is that mediation for? Agreeing on the arbitrator or the dispute?
For settlement of the dispute.
Settlement of the dispute. Go and sort out. Don't press this application. An application for appointment of an
Lordship,
arbitrator.
in that case, may I pray that the matter may be taken up coming, if we could not come to a consensus, we place
Alright.
for appointment.
List taken on 11th of June. Enabling the parties to complete their instructions whether the disputes can be resolved out of court by between the parties. 11.
Husband died, my lord, and petition number 2 is the minor daughter, petitioner 3 and 4, father and mother, my lord. After death of my husband, when I approached the authorities, I came to know that another wife has come and taken away the benefits. Now government has filed an affidavit stating that in the meantime my NOK has been modified and my name as a wife has been replaced. Then also my lord, petition number 2, 3 and 4 are eligible for receiving compensation of family pension as per
You are
petition number 1, the wife. As per my knowledge, I am the wife. And petition number 2 is my daughter, my daughter. 3 and 4 parents, my in-laws.
you are praying for what?
For pension, my lord, as per compensation of family pension.
So who is to get the pension? The wife.
Wife, my lord. Wife.
Then
If
why
they have,
why the others are filing joining in the
my wife is my lord. Not compensation, not pensionable job, my lord. As per notification 25, page 25.
yes?
Compassionate family pension till the date of actual in service. And that is family pension under 1960.
Yes.
I am behalf of the hi. Yeah. And academic.
You filed it.
I am not receiving.
Who is respondent 5?
Another one.
Oh, you are the second wife. Submitted that respondent number 5 has filed an affidavit today. However, the same not connected to the case record. Matter be listed after.
For that maybe.
May you like to file a reply?
Settle question. I am not entered at petition number 1. 3, 4 are
He listed on 18th. of June. Mr. J.K. Goswami.
Pension better, my lord. They are not pension. They are not 28, 25. So when the matter was moved, my lord, my learned and saying a certain document has not been, my lord, furnished. They have tried furnish the document, my lord, this document, my lord, but in not giving the pension. Even a provisional pension has not been given. There's order from your lordship.
Yes.
Lordship, as per our instruction on 26th of this May, department has forwarded his remaining other documents to the accountant general.
Forwarded.
Or
You forwarded.
forwarded. All the documents have been forwarded.
Accountant General? What does it say?
instruction in the month of December last year. By instruction.
You have forwarded it.
Yes,
When-
it's forwarded on 26th of May 2026.
Mr. R. Burua appears for the petitioner. Is the claim of the petitioner that the pensionary benefits have not been granted. So, there are Mr. K. Kumar, learned counsel, the additional AG appearing for the respondent. ENRD department submits that the pensionary benefits have been forwarded to the
Documents.
all the documents, proposals.
Proposal.
Has been forwarded to the accountant general's office. And so appearing for the accountant general. However, submits that the instructions in this regard are not complete. Is this matter again, let it come in July? The matter be listed immediately after reopening on 17 July. Tendency of the writ petition shall not be a bar to proceed for release of the provisional pension as entitled to the, as may be found, as may be found entitled to the petition. By which order? The respondents will proceed for release of the provisional pension in terms of the earlier order passed on 17/10/25.
All right.
On last occasion, the learned pain has submitted that I have been the promotion. But my case is I have already got the promotion before retirement. But I pay for notional benefit of promotion because I am entitled for the financial benefit since 2013. So I want only pay for notional benefit of promotion. I'm aware that I have been the promotion, that I have got the promotion. But in 2013, I should take a promotion. But promotion has been given lately. So I have paid and that process has been continued. Also, we find page 57. And already proposal has been given by the Director of Economic Statistics, page 57. Petitioners are applying for financial benefit to retroactive effect from year 2013. Communication is going on, but it is not given. That is why petitioner is approached on the court.
Yes, Mr. Sudhir.
One aspect, one of the director of economic and statistics, I have received instructions from them. And I want to affidavit, I will find affidavit, then take for final hearing. Response number 1 has already filed affidavit. Transformation and Development Department. So Statistics Department has not filed affidavit. Response number 2. After 3 weeks, in the meantime, I will file this affidavit.
What do you say, Mr. Goswami?
I have no objection to that. Also, may admit this petition and this hearing on after 2 weeks or 3 weeks.
After 3 weeks, then
Let the affidavit be filed. first.
one affidavit filed, but
Mr. S.K. Goswami, counsel, is for the petitioner. Mr. T.C. Zutia, additional senior government advocate, submits that instructions have been received. He would like to file the affidavit. And Ms. So-and-so appears for the accountant general. Finance, who has filed the affidavit?
response number 1,
Respondent 1. Already filed the affidavit. Release this matter again after 3 weeks.
Immediately after vacation.
Immediately after the, on a date to be fixed by the
Okay.
registrar.
As per the last order, government was directed to produce the original records and to place instructions as to whether the scheme for
transfer of physically disabled persons has been adopted by the state government. What is the scheme all about?
Also, here in this case also, what application is made was for an application. Therefore, there's some time is required to submit also. More time.
How much time?
4 weeks time is there.
Mr. S. A. Chamua appears for the petitioner. Mr. A. K. Goswami. State brief for 4 weeks time. Completely instruction and file necessary affidavit. Prayer may be allowed. The interim order passed early will be extended. Accordingly, this matter matter be listed in the first week of August. Interim order passed early will continue.
I have received one instruction. Department had asked the DLR to regarding the status of that DP. As per my instruction, my lord, that no DP is proceeding against the petitioner. And was not initiated before, my lord, that he was supervised.
Instructions now? No formal charges have been framed.
No departmental proceeding has been initiated against the petitioner at that time when he was that's happened. He was retired on 31/3/2022.
They have already accepted your prayer.
Pension,
Yes.
benefit or pension is not. I think it's communicated, madam. Regarding pensionary
Last
benefit.
paragraph, my lord, it has stated that.
Mr. M.J. Kadir appears for the petitioner. Mr. A. N.D. Deputy Department.
1 and 4.
He submits before the
5
court.
to 10.
uh, 5/5/26. Director of Land
Land
Records. Deputy Secretary, Government of Assam, Revenue and Disaster Management. See, Therefore, the government was requested to accord necessary instructions for finalization and release of regular pension to the writ petitioner, since there is no statutory bar. So, that view of the matter, we permit further 2 weeks' time to the 3 weeks' time to the learned standing council revenue. Place before the court any consequential or probable partner. Instruction is placed before the court is kept on record. Taking Goswami for 5 to 10. And Mr. Burua for Accountant General. Let us see what comes up. Which date? 17 July? 17 July. It's on 17 July. Right.
Under affidavit will file reply.
Mr. D.K. Das for the petitioner and Mr. D.K. Goswami for the respondent. As that affidavit is filed, respondent would like to file rejoinder. It's like placed accordingly after 3 weeks.
Interim order, there is interim order.
Interim order, if any, passed early, will continue.
Right.
File our application. You have filed?
Yes.
Yes, petitioner?
Last of all, the director to verify the record. What they call for.
My lord, this is the nowadays, my lord, e-office is operating, my lord. This is the printout of the e-office. How transfer was done, my lord.
Why was it done?
My lord, as per our affidavit, we have already clarified, my lord. And now one more thing I want to say. On that day, not only petitioner, my lord, in the commissionerate, my lord, numbers of my lord employees were transferred, my lord, intra-district, my lord. This is to show that, my lord. Because our vacancies are lying in different districts, my lord, we have rationalized the employees, my lord. We have the power, my lord. In our affidavit, we have annexed the, my lord, guideline.
Oh, he's see, he
Was since last 6 years he was
he
there.
was initially transferred on March 2019.
That was statement.
Then again in October 21. Then November 23. Then February 25.
Those were, my lord, intra-district transfers, my lord.
Then finally March 26.
That is by the commissioner, my lord.
Why so many transfers?
Because, my lord, that was
earlier transfer was made by district commissioner, my lord. District commissioner has the power. Within the district, he can rationalize their employees. And as per the guideline, my lord, the commissioner can transfer out of the district also, my lord. We are not questioning your power. We want to know why you're exercising your power like this. On the other dates also, how many persons were transferred? My lord, on the same date, I have submitted few of them, my lord. Almost, my lord, 10 members transferred. Are the pleadings exchanged, complete? They have not replied, man. You want to file a reply?
Yes.
Then you file your reply.
And one more I would like to say before you answer. In the pendency of this case and where there is a status quo order, they have passed this order by which they have allocated the place of this present petitioner to the other accredited engineer by which they
You bring it on record by the
Yes.
additional rejoinder affidavit. The counsel for the petitioner is permitted 3 weeks' time to file rejoinder affidavit. Mr. S. Dotto appears for the PNRD. This after 3 weeks.
are on an interim
Interim order passed early in the continue.
I know.
So by this petition, not the petitioner, not the raise for release of the vice salary, the ROP 7 pay commission, because my lord, 12 junior, 12 employee junior to this present petition, they have been given that salary as per the ROP 7 pay commission. And the last date, my lord, the respondent number 5, municipal board. Upon respondent number 5 and 6, my lord, the last date 4/5/2026, Director of Municipal Administration was directed to issue communication to the respondent number 5 and 6.
Lordship, this was communicated, Lordship, and seek some time to get the instruction from the executive officer of the municipal board.
Respondent number 5 and 6, my lord, they
Yes,
did not
Lordship,
turn up.
the six on behalf of six, Lordship, six the executive officer that I will stand, Lordship, and I have to take some instruction. Already it was communicated.
How much time you want?
Lordship, 2 weeks time.
The name of the last week.
Lordship, the affidavit has been sent for vetting, your lordship.
This is the case for dismissal,
No, Lordship, regularization.
regularization.
Regularization plus the pensionary benefit.
What is vetting? I don't understand. Why you send it for vetting or correction in your form? Why do you keep saying it's sent for vetting?
Lordship authorized signatures.
We know an affidavit has to be filed by a person authorized to sign. So what you do when your client is up to you? How? Counsel for the respondent
One and
raised for and is granted
2 weeks time.
weeks time to file their counter affidavit.
And for
So
respondent
these
number
only
1
appeal
and
for the
2.
question.
And for respondent number 1 and 2.
MS so and so appeals for respondent 1 and 2. Who are the other respondents? One and two. Mr. J.K. Goswami for respondent 3.
Yes, Lordship.
Released after 2 weeks on a date to be fixed later.
My privilege. Herein, today, your lordship, I have received the copy of additional affidavit filed with the respondent. Want to file my file.
The name can go to the petitioner and then the affidavit filed by the respondent has been received during the course of the day.
It was received, one of my colleague, your lordship, once in
As the
2020,
recently received the affidavit, he would like to file his rejoinder. This after 3 weeks.
Can it be your lordship after?
Let it come after vacation.
I am saying.